Jeannie Carlson,
Here.
David Langworthy, Mark Nelson,
Here.
Laurel Preston,
Here.
Randy Reeves,
Here.
Sean Schubring,
Present.
Nicole Truitt. Here.
I haven't heard from David, so he may show up here a little bit later. I'm assuming he'll be able to make
Yeah,
it.
we'll let him.
Yeah.
Announcements.
So I've got a couple announcements for you tonight. I'll try to keep it fairly brief because we have a pretty full schedule tonight. First, wanted to note for you guys, I don't know if you got in the mail yet, but the postcards for the open house that we have scheduled for the 25th. So we also have I don't know how many of you are signed up to get our newsletter, but the newsletter also has an article about this too, and we've got it on our website, and we send out eGov and stuff. So we're trying to get the word out, and I'll probably be working with OTEC to set up some displays and stuff, but keep in mind that's I believe it was the 25th that we've got that scheduled for. So, and that'll be an open house meeting for anybody that's here that wants, get the word out and stuff on it. Other thing I'd like to let you guys know, we have a new assistant city attorney tonight. Brian is joining us. I'll let Brian kind of introduce himself a little bit more to the group here.
So, hi everyone, my name is Brian Epley. I'm filling in for Josh Lane and Scott Massal, who's the interim city attorney. Just for your education, I have background in land use, municipal and environmental litigation and regulatory matters.
And just so you're aware, the firm that he's with is actually merging with Ogden Murphy Wallace, I think starting next week?
Starting Monday.
Starting Monday. So that's actually going to be our new law firm who will be, they're the only ones that actually applied. So he'll be with us here most likely long term. So anyway, again, Brian, welcome to the Planning Commission. Note also for the April meeting, Planning Commission meeting is on a different day than usual. Normally it's the fourth Tuesday, but we're going to be doing it April 18th, which is a Wednesday. That's because I will be actually out of town. So just make sure you make a note on that. And then finally, I just wanted to just highlight for you guys the new formatting that we're doing with the minutes, and also you'll see the agenda. This is actually to reflect, the council's already been using this format, I think, for over a year, maybe 2 years now. So what we're working on is trying to bring consistency across all the boards and planning commission and council, so that it's all the minutes, all the agendas and stuff are following a very similar pattern. The advantage of this also is then we are setting it up on the website, so if you download it, you can actually link onto individual, instead of having to download the entire package, you can actually just go to the individual agenda items and pull those up. So, and just a couple other things to note for you too. The Easter egg hunt is this Saturday I don't know if any of you were planning to attend, but they will be having that starting at 10 a.m. And it should be a lot of fun for the kids. I think it's going to be pretty much a mud bath out there for them, but it's already kind of swampy out there, and I think I've heard that the weather's going to continue being like this the rest of the week. But I believe they will have the Easter egg hunt rain or shine, the way I understand it. So, and then the other thing I want to note, there is another open house. You probably have seen on 84th the signs for the project coming up. We've talked about this previously in some earlier meetings. There is going to be one final open house April 5th. That's Thursday. I believe that's next week at 6 p.m. So you're welcome to come attend if you have questions, or anybody that might have questions about the project before it gets started. I think it's slated to start at the end of April, beginning of May, and it's scheduled to potentially go through the end of October, beginning of November. At least at the time when the contractor has to work on it. So those are my announcements.
So it's your commissioners.
Yeah, in case anybody else has anything they want to offer for the good of the group.
Mark? Nicole? Jeannie? Okay. Approval of minutes.
Move to approve both minutes, if that's legal to do.
Sure.
Second.
You gotta say it twice.
Second.
Both motioned, both seconded. All four?
Aye.
Opposed? Minutes are approved. Audience participation.
I do have one speaker card, but it's regarding the zoning, the rooftop.
So, Mr. Chair, just for the record, Ian Morrison, we have a very short comment, but we would defer to the commission, but if you'd like, we can hold that public comment
It's your chair. It's gonna be 2.5, 3 hours. Okay,
Happy, we're looking forward to the discussion.
no audience participation. All right, presentations, here we go.
So, some of you guys, a lot of you were on the planning commission a couple of years ago when Ted Hunter, and I think was Andrew with you a couple of years ago as well? Yeah, did some training for how to build a record for quasi judicial. So we've invited Sound Law back here with Ted and Andrew today to give some more training because we have some new members. And I think you'll probably kind of go a little bit over some of the stuff before as well. So I think there may be some new things tonight just to kind of introduce you. So I gave kind of a quick summary from your website. It's in the packet. If there's anything else you guys want to say more in introducing yourself to them, you're more than welcome to. But the floor is yours.
Well, great. Thank you, Robert, and thank you for inviting us to come back after the presentation that we made a couple years ago. That was very enjoyable for us because it's really a rare opportunity for us to see Planning Commission members, yet part of what you do really impacts us as hearing examiners. So it's really, we're very grateful to have an opportunity to dialogue. And that's what I hope we do tonight, that it's not just one way, but that when you have questions or maybe concerns about what we say, that you go ahead and interrupt us so we can address those right away. Especially appreciative to see the mayor here this evening who returned to hear the presentation, and thank you, Ian Morrison, for yielding the floor. I gave him the opportunity to go before us, but he said he wanted to hear it again too. So we've got a lot of different angles that we're addressing, but our focus is on the Planning Commission members because you have a very important job in the city of Medina, as do we, as does the council, and all those involved in land use decision making. So the opening slide is to recognize that land use decisions are a blend of politics and law. We're here, the two of us, Andrew and myself, as attorneys, and we have extensive attorney background. That's one reason you retained us as your hearing examiners. We focus only on the law. Robert and I have worked together for more than 10 years, I think.
2003.
Beginning in Bremerton 15 years ago. And Robert is very supportive of what we do and how they prepare staff reports with his planning staff now. Those are all focused on the law. There's no blend, none at all. As Planning Commission members, you're playing a couple different roles. You were kind of in a legislative process. You look at comprehensive plans. You look at advising on ordinances and advising the council. Very legislative. You want the whole polis, the whole city, the politics to enter into that, to be aware of what the different viewpoints might be in your community. Then you also, and I think you have one tonight, where you make decisions on specific applications. You're holding on to a couple of those. The construction management plan is one and the site plan is the other. At one time, planning commissions did conditional uses, variances, preliminary plats, and a broad array. Gee, why did that change? Well, the blend of politics and law became so obscured that a case way back when, in 1969, Smith versus Skagit County. Do you remember that case, Ian? He's nodding his head. I got to test him from time to time. We were mentor and mentee as he was in law school, so I'm really thrilled to see him. And he remembers Smith versus Skagit County. Guaymas Island, Anacortes, Skagit County. Wow, this is beautiful. Let's preserve this land forever. And they did that. And then an aluminum company came and said, you know, we need about 700 acres, and that fits us, our needs pretty well. We'd like to rezone it and put our aluminum plant there. And lo and behold, they had 400 or 500 people involved in hearings. The Planning Commission held the initial hearings to advise the 3 members of the Skagit County Board of Commissioners. And their advice was, no, you really shouldn't do that. Rezone. It's beautiful land. Let's save it. But the 3 commissioners, after meeting as commissioners and saying, well, we got the Planning Commission recommendation, let's go into executive session. And they invited the Alcoa people to come in to the executive session behind closed doors. The opponents, no, you please stay out. We heard about you at the hearing of the Planning Commission. We're going to make the decision with Alcoa tonight. And they did, and they approved the rezone. Even though the Planning Commission thought, no, the planners said not a good idea. And they did that, and it went into court. with an attorney named Tom Ehrlichman, and they really, really protested that that's not the right way to make land use decisions. So our court back in 1969 said, you got to get politics out of land use decision making. It has to follow a process that's a legal process. And that was the start, really, of the hearing examiner system. Because shortly after that, the legislature said, we're going to authorize cities, planning commissions, to delegate, and councils, delegate to a hearing examiner land use decisions to get the politics out of that decision making. Now, the slide we have up now kind of shows who all the actors are. So the legislature grants us authority, and we're going to touch on a couple of state statutes that we want you guys to be aware of as planning commission members, because when you make quasi-judicial decisions, you want to be aware of these statutes. And similarly, when you make legislative decisions, you want to be aware of these statutes. And we're going to help you decide when is it quasi-judicial, when is it legislative, but being aware of the state statutes is important. City council, they also guide you. They give you authorization to do certain things or ask for recommendations or advice. That's what you do as the planning commission. And then we have probably the easiest job in some ways because we're all law. All we care about is the law. We might want clear advice or direction from the council. We might get an appeal on occasion from the planning commission, but we have blinders on and say, what does the law say? What does the state statute say? What does the city ordinance say? That's all we are concerned about. And then we make a decision based on that law. What's next? So let's look at these state statutes, because they really are the starting point for guiding what you do as planning commissioner members, what we do as hearing examiners, and they grant the city the authority to do these things. And the first Growth Management Act, you've all heard about it. It's rare that we read about it. Let's go back to that constitutional slide for a moment. Where did that one go? There it is. The Growth Management Act is an effort to do the balance. And you, like us, like the City Council, we're on the same team. We all are doing constitutional work. We're all involved in implementing our U.S. and state constitutions. And what they require, as we can see here in the Fifth Amendment, no person may be deprived of property without due process of law. That's what we're going to focus on tonight. And no private property be taken without compensation. That sets up the balance. And the balance is, if you go too far in regulation, you advise the council, oh, I don't know, to do something with trees, for example. Maybe it goes too far, and maybe that gets out of balance. And who knows, it might have to be revoked. I don't know if that had ever happened in the city of Medina, but it happens in places where it goes a little bit too far. It upsets the balance. Each community has a little bit different balance. The courts give us a sense of where that balance should be. And if it goes too far, it might have to result in compensation. That's what the Constitution advises us of. And there's another federal statute, Constitution and the statute. Did you want to talk about?
Sure.
I want to give Andrew an opportunity to talk
okay.
about.
The setup is a little awkward, but this is codified in 42 USC 1983, and the attorneys in the room will know this is a Section 1983 claim, but essentially what that says is that when you act under color of any statute, ordinance, or regulation, and you've deprived a citizen of any rights, privileges, or immunities secured by the Constitution and laws, you shall be liable to the injured party. What that means,
that's a
it's a lot of words, it's a lot of gobbledygook, but what it really means is that there is the potential for those serving in their capacity as sort of actors, commission members, even the hearing examiner, to be sued under the law for not following the rules and the statutes that are in place.
Not following due process. And that's what we're going to touch on. When you put on your quasi-judicial hat and you're making an individual decision on an application, you've got to follow the due process that we're going to talk about tonight. That's where our focus is going to be. Failure to do so and I'm sure your WCIA city, I'm sure they told you this, you can be individually sued when you are wearing that quasi-judicial hat and making a decision on an application. You can be sued for damages if you don't follow the proper process. So that's where our focus is going to go next, under the proper process. It's rare that a court will overturn a decision because they don't like the decision. But if you don't follow the process, they're going to get involved and say, vacate that decision, follow the proper process, and even worse, put damages on that. So back to our Growth Management Act, that is a balance of private rights and public interest. We have on the slide some of the things you're very familiar with. As Planning Commissioner members, you're looking at comprehensive plan. Legislative or quasi-judicial? What do you think?
Legislative.
Definitely legislative. Always you can be confident about that. Now, adopting development regulations consistent with and implementing the comprehensive plan. That's a requirement. This was just a breakthrough, nobody ever thought this would happen kind of thing, that your development regulations now are to be consistent with the comprehensive plan. Earlier time, there were proposals, I remember one in Bellevue, even when I was a young attorney, it was zoned, it was comprehensive plan, was for residential development, and the zoning was residential, and then a developer came in and wanted to build a big shopping mall, Crossroads, something like that, and oh my gosh, you can't do that, that's residential. Oh, I think we can. And got it changed, the zoning, to commercial zoning. Comprehensive plan still says residential. Went to court, court said, well, comprehensive plan doesn't really matter. It's just a guide, it's a blueprint, it can be ignored. And it was routinely ignored in the state of Washington until the Growth Management Act. That's really a lot of what was behind the Growth Management Act. So the work you're involved in, when you're looking at ordinances that are implementing the comprehensive plan, you are always thinking about, is it consistent? Does it implement the comp plan? Another legislative action. You've dealt with critical areas, you've dealt with countywide policies. The hearing board is another thing. It was a major effort of the legislature to get things out of courts. Second act we want you to be aware of, and this affects us in our daily work, is a state statute called the Regulatory Reform Act. 1996, I believe that went into effect. One hearing, big deal, one hearing, only one hearing on an application. No opportunity to say, well, we can't decide tonight, why don't you come back next month? We'll have another hearing, we'll figure it out then. That happened routinely. A company called Boeing was very upset about some delays they'd had with their construction plans up in Payne Field. They went to the legislature, I think that year they met in a Boeing hangar, and they said, you know, we need to change this law. And they did it. And one hearing, that's all you can have. That is really, really important. And there are time frames. And your planning staff is very familiar with 120 days. You got to make a decision, complete application, change the world of land use. This affects your world as planning commissioners because how you make the decision on the application, you need to be mindful of the Regulatory Reform Act. And your planning staff will remind you, but one hearing. Timelines, we talked about that. Open record hearing. Oh, well, you know, you make decisions, and sometimes we see appeals from you guys. And can we have another hearing? No. It'd have to be a closed record hearing or an open record appeal. And that's what the Regulatory Reform Act talks about. That's enough on that.
Can you explain to them real quick what open and closed means?
Yeah, and I don't think you're going to see a closed record decision. You do?
No, they won't.
No, you never do. What that means is that a hearing's been held, maybe, or a decision's been made, and all you see as a decision maker is the record that was compiled before that decision was made. And you can't take in any new evidence. That's one of the keys.
And we've had situations in other jurisdictions, which will not be named, where, for instance, a final plat review, they ask us as a hearing examiner to make a recommendation, and then that's an open record hearing that we hold where we do gather evidence and maybe members of the public testify produce our recommendation in the form of a decision that goes to the planning commission, and then at that point, they're supposed to hold a closed record hearing where they do not gather any additional evidence. But we know in several jurisdictions, there's the potential for getting in trouble with the Regulatory Reform Act because a commission member might say, oh, I wish we had the engineer here to tell us more, and they'll call them up
Yeah.
and get a whole bunch of new evidence,
Yeah.
and that is
It's
a big
really-
no under the Regulatory Reform
Or your
Act.
city council when they see a closed record appeal, and it's really hard for an attorney to step in and say, no, you really can't take new information. I think that's got to be one of the tougher things to do. Have you ever been in that position?
I have not been in that position.
But you
thankfully.
probably really fear it because council members want more information before they decide. But you really kind of have to say, no, you can't get more information, which really doesn't sound right politically. You've got to vote on what's on the record. Now, thankfully, you're not going to have to worry about that as planning commission members. So that's a big load off you, which is great. Now, here's what you do have to worry about. Let's get into the heart of it. Let's get into the thick of it now. This is really like the incredibly important stuff. You be the judge. This is when you are the judge. Somebody said, oh, I saw you be the judge presentation several years ago. I'm afraid it's getting to be a bit of a broken record for me. But the law is always changing. So these are things we want you to be very confident about, that you know what appearance of fairness is, you know what it means to have notice and opportunity to be heard, you know what the record is, and you know how to act within the scope of your authority. So this is what might be known as procedural due process. So let's maybe,
I don't think.
go ahead. Well, it is by statute, there is,
Sorry, I think you wanted to touch on these. I don't think we have specific slides.
okay, appearance of fairness. You've been briefed on that by your city attorney, I'm sure, on what appearance of
They do
fairness
appearance of
is.
fairness before they hold their
And you
hearings.
disclose it, yeah.
And I think the point to stress is that when you're acting in that quasi-judicial capacity, it's not just that you have to be fair, it's that to any outside observer, it has to appear that you're fair. It's a higher standard, and we kind of don't, it's a, a legal fiction, but when you think about it, it's, oh, I know I'm acting fairly, but would a random person that just walks in feel that I'm acting fairly given what they know? And that's the heightened standard that I think sometimes we don't think through as not attorneys.
Particularly important on the application hearings where you're working in a quasi-judicial capacity. Quasi, just like sort of like a judge. They're going to apply the same standards that a judge would have, but you're not a judge, but you're quasi-judicial. Do you disclose for legislative matters as well as quasi-judicial? Okay, yeah, and that's fine. So this is where, again, you're looking at, yes, there's a blend of law and politics, but if you're in a political sitting and setting, you can be as prejudicial as you want, I guess. You can, have strong opinions and bring them into the room. And that's okay. Nobody's going to pound you over the head for doing that. If you're sitting on an application and you make a comment that, like my neighbor told me this, or I live next door to this application, I have pretty strong feelings about it, and I vote no, you're probably going to get in trouble. So you want to be aware of it, and if there's any doubt, you disclose. And I'm sure you talked about this. The cool thing about that is it's disclosure. That doesn't necessarily mean that you have to step aside, only if somebody objects. But if you don't disclose and it's found out later that you should have disclosed, then you might upset the whole decision-making process. So as you prepare for the application hearing, you're thinking, is it something, our kids go to school together, should I disclose that? I don't know. It may be not, well, do it anyway. If there's any doubt, say, I just wanted to let you know that my daughter goes to school with the applicant's son. I don't think it's going to affect my decision, but I want to disclose it. Then the key thing is, maybe your chair does this, is there anyone in the room that objects to this commissioner? Yeah.
Is there any precedent for doing legislative as well? Disclosing?
Well, yeah, and it's let's go back to that. It's a statute. Where did we put that statute? There is, and this is something that is in the state statute for optional municipal cities. And it is silent as to whether you must disclose for legislative as well as quasi-judicial. That's why I put the slide in here. This is very dense slide, and I've never used it before, and I'm not really sure I want to get too much into it, but it does say, if any person on the planning agency concludes that he or she has a conflict of interest or an appearance of fairness problem with respect to a matter pending before the agency, it doesn't say quasi-judicial matter. And have you run into this before?
I have not run into appearance of fairness, and especially not in the legislative
Yeah,
context.
but this statute, you read this statute and it sounds like it applies to both. Have you ever protested, Ian Morrison, on legislative matter?
In a legislative context, we have not protested because, as you say, Mr. Examiner, this is something where the courts are a little bit, I think the clear case, we read the statute to say that this would not, appearance of fairness would not apply in the legislative context.
Yeah, you can read it that way if you're a really smart attorney like Ian, but it doesn't say that. But the answer is, I don't think you have to, and I would not get into disclosing on legislative matters. Because the whole purpose is, you want there to be this mix of point of views and broad spectrum and kind of get into a rumble with each other, because now you're kind of getting the whole spectrum of views, and that's what you want to do. Never, ever do that on an application. So we're going to get rid of that slide.
Okay,
Yeah.
are we moving forward?
Well, we're back to due process,
Okay.
because we just touched on appearance of fairness.
Oh, shoot, sorry. Back
Yeah.
here.
Notice.
Thank
And again, you got a great planning staff, so they're taking care of this problem for you. Although, even so, with technology, with so many requirements on notice, with things slipping here and there, each of you as planning commission members should be aware of notice for an application hearing as well as notice for a legislative hearing. And if you don't hear your planning director or planning staff say, this is how we gave notice, ask about it. And that makes you look smart, because we got to have proper notice. Or if you see something, you don't see the notice of publication and you think it should be there, ask about it. You're never going to look dumb asking about notice. It's going to show that you are aware of the importance in due process. This is procedural due process of the need to have notice as part of your record. And if you don't, you're vulnerable to getting attacked for the decision, to getting liability if the disagreement with the decision.
Ted, does notice have to be perfect in Washington?
Well, that's a pretty strict standard. And at one time, that's what the courts required, that you must give notice in strict compliance with the ordinances. Now, thank you, Regulatory Reform Act, 1996, it freed the city, and now the standard is reasonable notice in the following ways. And typically, your community here is adhering to each of the strict requirements still. That's a good practice. But, for example, you forgot to post it on the city hall door. You could probably still hold the hearing, but that's going to be up to you guys. If there's a flaw in notice, do you want to wait and re-notice it? Or do you want to go forward figuring there's reasonable notice? We have to make that judgment call from time to time. How do you make that decision, Andrew?
I decide whether or not notice was reasonably calculated to apprise.
But how do you make that? What do you base that on?
I base it a lot on attendance.
Yes.
If there's a lot of folks interested, especially folks that say, well, I didn't get the mailed notice, and I go, well, you're here, so clearly you got notice somehow. Can you explain for me how you heard about this hearing? Oh, well, it was posted on the city website. I saw it on the
okay.
bulletin board. If it becomes clear that notice was out there, even if it was slightly imperfect, I'm usually comfortable moving forward. I might say, if it was a real sort of on the fence situation, this is very rare, but might say if someone comes forth that, and it's revealed that they didn't receive proper notice, that the hearing may be continued, I might start working on a decision, but I'd set a date whereby, because again, on the one hearing issue, Ted didn't clarify this, but you can leave the record open on a hearing. You just can't sort of hold a hearing, close the record, and then decide later I'm going to hold a new hearing.
Excellent.
You can have more than one
good point.
hearing
You
day,
can
but-
continue the hearing. If you, sometimes you might have a lot of people interested and they're testifying, and we'll never go past 10 o'clock at night. I don't know what your practice is. You do go past 10 o'clock at night? No. No, some cities,
They don't like me if we get even close to
Right,
10.
and that's really smart. Some cities kind of pride themselves. I'll talk to planners. How are you doing today? Oh, man, we went to 12:30 a.m., man. I'll tell you, it's a rough day, boy, but we went to 12. They're almost proud of how long they go. That's not a pride thing. You know, you should know how to run a hearing so that you're not going past a reasonable hour. But if it does happen, like Andrew said, we're going to continue this hearing. We're going to reopen it, whatever date it's going to be. You don't have to renotice. You announce it at the hearing. Continuances are your friend. And you can do that for any reason you want to. We're going to continue this, come back on the record, and I'd like to hear from the applicant at that time. So consider that a strategy.
Right, can I add in this too about the noticing? So you can correct me if I'm incorrect on this, but basically our ordinances establish the minimum requirements. And so that's one of the things I think you use to judge, because, for example, we don't require to, on a CMP or on a quasi-judicial matter, we don't require you to notify the entire city on a public hearing. There is actually a particular code language that actually lays out 300 feet as the minimum requirement. Then we've actually added a couple of additional restrictions on it. And then you guys are informed about the noticing through two things. When it's a quasi-judicial, the staff report gives you the summary of what we've done for noticing. And when it's legislative, what we do is when you see when you're holding a public hearing and you see the whereas clauses, it's outlined in the whereas clauses in the Planning Commission recommendation. So that's one of the ways we notify you of what we have done for public noticing. So if you're ever curious, in the course of this staff report, or in the case of legislative, it's actually in the language of the ordinance in the whereas clauses that we do.
Yeah, or go ahead and ask, because the next thing is the record of decision. And that looks really good if there's a transcription of the record of one of you as commission members saying, could you tell me about the notice for this hearing tonight, how that notice was given? And even though it might be in the materials, we do this a lot as your hearing examiners. We will ask questions of the planner that we know the answer to, but we want to build the record to make certain, particularly if somebody's saying, well, I'm not sure I got notice. Could you please tell me how you did give notice tonight? And then it's in the record. The record of decision, you as well as us have to write decisions in a certain way. You've got staff that'll help you with findings and conclusions. And this is by judicial fiat. It's a case called Weyerhaeuser versus Pierce County that gives us instruction on how we must write decisions. Your planning staff has become very familiar. If we write a finding of fact, which you do too, we want to make sure we have an exhibit or testimony that supports that. So you're preparing the decisions for Planning Commission?
Yeah, they don't actually see the final decision, because they make their vote, and then we have 2 weeks afterwards to actually draft the decision and get it out. We actually added time because there's no way to actually draft the decision, because you don't know the Planning Commission's decision until they've made it.
Cool.
So they make a decision, then we drop the decision afterwards and have 2 weeks to do that, just like you do.
Okay.
Getting a decision out.
Well, you can trust your staff. That's what they're going to do. And then their conclusion is going to reference findings. And there's a reconsideration process. If for some reason you read it and you go, wait a minute, I don't think that's what I wanted to have happen, you too can ask, can we bring this up at a future meeting and have it reconsidered, or ask staff. It's a rare thing, a rare tool, but if you really don't feel right about it, you want to make sure your record supports your decision. That's the point here. And that your act, go ahead.
Are there limitations in asking for reconsideration like there are in some other decisions that it has to only be by the party that was in favor?
No, like Robert's Rules of Order. Not that limitation. There are often limitations about it has to be new evidence, or it was a mistake of fact, or a mistake of law.
Okay.
In our experience, anyone asking for reconsideration generally ignores those and just says, I want it reconsidered. But I think what you might see, given how you decide it's written up, you might see a mistake of fact. You might say, you know, I thought that proposal for construction management had them starting at 8 a.m., not 7, And, I think that's a mistake. I think we have clearly on the record it was going to be 8. And then you can ask, can you please take a look at that? And then the exercise would be finding in the record where that discussion happened. That's why everything's recorded. And oh my gosh, maybe you're right. You're right. It should have been 8.
And
What
the-
if I'm on the planning commission and I just didn't realize how annoyed everyone was going to be with the decision? Is that potential grounds for reconsideration?
You're not ready for the planning commission. People will be annoyed at some decisions, but you're not, I don't think that's grounds.
There,
That's your
that
point. Okay.
And I know the ordinance actually lays out the criteria for reconsideration. We actually have adopted standards.
Yeah, yeah. The point here is don't be afraid of it. Look into it, because if your gut says something's not right about this, I don't think it's what we decided. It's better to address it in that process than to have it go forward and find out later there wasn't support for that finding.
Thank you.
And then acting within scope of authority. That's going to be, your city attorney is going to advise you if you get outside the scope, like on the closed record, which you don't see, but you're listening. And if it wanders too far, you have any examples where you've gotten involved and said, I'm sorry, I think you're wandering outside of your authority?
Not specifically with ultraviewers, but that's certainly something to keep your eye on.
It could happen. You've released most of your decision-making authority on applications, so you can really focus on the legislative stuff. And that's really, really smart. And we found in jurisdictions that have given everything over to a hearing examiner, the planning commission becomes much more efficient. You don't have to worry about, am I going to get in trouble? Are we making these decisions properly? Did we hold the hearing correctly? Did we act outside the scope of our authority? You're not going to have to worry about things like that because they don't have a cost consequence, a liability aspect to them like that you do for individual decision making. Something that just happened last legislative session is that it used to be that only the city council could make final plat. Now, you don't see many plats here at all.
I don't think there's been one here since
I don't
the
think
80s.
there's been a plat. So I think the last one was about 1902.
Okay. We do get short plats, but that's not council,
Yeah.
so.
But it used to be that councils had to make the final plat decision, and now that can be an administrative determination. So if you get tired of holding hearings, we never do. We love hearings. So you can give it over to us, and then we'd be acting within, our scope of authority as your hearings examiners is determined only by your ordinances. And what you say in our ordinances, we pay very close attention to. If we can't figure it out exactly what you mean, we'll probably put a footnote in saying, we think when the council adopted the ordinance, they meant this. But if not, we'll have to rethink this decision. We ask for guidance.
Sure, or at the hearing, we'll ask Robert, as the director, what his interpretation of an ordinance is, and we give deference.
Yes, we give great deference.
Great deference.
Great deference. And that's a legal test. You can give deference, and you can too when you're making a decision, deference to your planner if they have interpreted the ordinance consistently. You can't give deference. They say, well, in the past we said a variance can be granted if there's a special circumstance, but on this one, I think we can grant it anyway, even though there hasn't been a special circumstance. That'd be okay. No deference, because it's a change of the consistency of the planner's interpretation.
Then we want to go to the tail end of the
Well,
process?
I think so. We're going to go to the tail end. This is if something goes wrong.
There you go.
Yeah, and I'm sure there's attorneys in the room that have been involved in these. I know I have. And I should mention my friend and colleague Andrew, he wrote for several years with the Division II Court of Appeals. And so he is very learned and skilled in knowing when there's a vulnerability in a decision that might come up on an appeal. This is how he would see them. They would start under the Land Use Petition Act. This was, again, a major change, 1995, where before you had all these special writs. And when I was a young attorney, we'd file writs of certiorari and writs of mandamus. Did you even study those in law school?
No, I came well after LUPA was passed.
Yeah, yeah. So, he doesn't even know about that good stuff, but it was a lot of fun. And now it's much more streamlined and strict because under LUPA, as we know it, Land Use Petition Act, You have to have a very specific reason for your appeal. You're supposed to narrow the record and not bring everything in front of a judge. Writ of certiorari, you brought boxes in front of the judge and said, it's somewhere in here, Your Honor. Now, what's supposed to happen is you narrow it down to the issues. So it really is designed to get timely review and eliminate the multi-year delays that used to happen. You're not going to see loop appeal on your construction management plans typically. I don't think there's been one.
No, in fact, in the 10 years I've been here, there's only been, I think, 2 decisions that actually have been appealed up into the courts. We had one was a loop and the other was a federal,
Yeah.
and that's been
Yeah.
it.
Well, see, and that's good news. That's because training is one, Andrew's another, because he looks at stuff in our office and says, uh-oh, this is one that might get appealed, and we're really focused on legal defensibility. Our real framework starts with, is it legally defensible, and is it understandable? And we try to write at about a high school level. You hopefully won't see any legalese in our decisions, because we want them to be ones that public understands, and then very legally defensible. That's why we've worked with your city insurance authority and used to give trainings, because training is a key element to prevent liability. If the commissioners and council have been trained, that's one element that the WCA looks at, and they give you actually a better rate if you've been trained. So we're very aware of exposure. Thankfully, you haven't had this. So let's go, we don't even need to talk about that. No, yeah. All right, yeah.
Move into those?
Well, I think so, because now's the time to see, has anybody been listening? So we've got a couple of scenarios here. Is anybody a new member of the Planning Commission? All right, this one's for you. The agenda includes proposed amendments to the comprehensive plan. One of those impacts property near where you live. The chair asked, are there any conflicts of interest which must be disclosed?
Well, according to what you said, you have a duty to disclose, and then somebody has an opportunity to object. But the understanding is this is a commission meant to reflect the community opinion. So if somebody objects, then I would imagine you can't weigh in on the topic. But as long as the disclosure is made, that's the most important part.
If somebody objects, I guess, can you have them removed, or is the chair or vice chair, can you ask somebody to recuse themselves?
I'd remove the one that objects, frankly. I'd get them out of here.
I'm with you too.
I mean, that takes a lot of guts
I like
to
the
do that.
commissioners usually more, but I mean, is there,
Yeah.
again, you're speaking of liability.
Yeah.
And obviously the hypothetical. So-
Yeah, well, let's clarify, because that was a pretty good answer, but we're now in a legislative context because it's an amendment to the comprehensive plan. So,
I want to be clear.
yeah, I
Alright.
loved your answer, but
Yeah, that was my answer was I would revise for quasi-judicial
Yes.
opinions.
There you go.
that's the right answer for quasi-judicial.
According to RCW 35A 6320, it's unclear regarding legislative matters.
Yes,
And
it is.
we should not necessarily back down from discussion.
You took really good notes. That's right. That's excellent. And as we heard earlier, your chair is not going to even ask you on conflicts if it's legislative. So if it's a comp plan, you're probably going to go right into, we have a proposal to amend the comprehensive plan, and you won't be asked that question. So you're not going to have to worry when you got professional staff that's determining, is it quasi-judicial? Now, if you have, next we're going to turn to an application for approval of a construction management plan. Then your chair is going to kick in and say, I want to ask the commissioners, is there anyone here that feels they have any conflict of interest or other appearance of fairness problem, the issue that they want to disclose? And that's when you say, this property is right next door to mine, and I do have some feelings about it. Now, you can say, I don't know if this happens with your commission, some planning commissions, the commissioner might say, but I believe I can hear it fairly, so I'd like to continue to sit if there's no objections. Now, somebody does object. You know, I think you're probably against this. I'm for it, so I object to you sitting because I don't think you can hear it fairly. Now it's kicked back into your court. Yeah, I think the wise thing probably politically, is to say, all right, then I'll recuse myself. But you don't have to. You should look to the city attorney and say, gee, what should I do? This person objects. What advice might you give?
I would advise them that it would be wise to recuse themselves from the decision,
Yeah.
maintain appearance of fairness.
Yeah, and he did that with such a solemn and graceful response. You probably would. Now, some haven't, and this happened, well, some Eastern Washington counties, so they're all different anyway, but someone said, no, I'm going to sit and hear this, even though that objector objects to me having a couple telephone conversations. I don't think that turned my mind in any way. I'm going to participate in this hearing, and I'm going to vote for this application. I don't think he quite said that, but he did vote for it. And then they uncovered telephone records. It was more than just one or two. It was 40, 50. Do you remember the name of that case?
I think that was Klickitat County, right?
Thank you. He was so well mentored in law school. I love it. He's got it at his fingertips. Or is he looking them up on the computer? He's amazing. He's that good. But that's what happened. So that's a consequence of not following your city attorney's advice. I'm going to do it anyway. You might get caught, because once a lawsuit is filed, there's all sorts of opportunity to ask you questions about that statement that you made. So I think you've got a good idea of what to do now.
Yeah.
Okay. And if the chair disagrees, you know, you do have some power as the chair, and you might want to have that discussion. Seriously, Commissioner, do you want to rethink that? Because I think we heard from the city attorney it'd be wise to step aside and recuse yourself from participation. And most then will actually, okay, let me know when you're done. I'm going to go read a book, and we'll leave the room. I don't think it's fatal to stay in the room. Do you think it's fatal? Not a good idea.
Probably not a good idea, especially if you're going to be trying to influence towards the remaining decision
Yeah.
makers. Yeah.
And you've got a face that would influence, because he's raising his eyebrows at some things I'm saying tonight, like, really? But yeah, if you're going to be there as an influence by your presence, best to get out of the room.
Yeah, and usually because we've had this happen before, actually. We had a planning commission member, not on the current planning commission, but a while back, that had commented on a CMP application and then did recuse himself from the decision, but then actually provided testimony during the hearing on it, opposed to the project. And one of the ways we handled that at that time was we did ask if the applicant had any objection. So we continued to ask those questions if there was any objection through it to get it on the record. And they did not object to that person staying in the room or testifying. So we had that on the record to address it, because that person did not want to leave. They wanted to comment. Even though they already had written comments in the record, they wanted to verbally also testify.
But with no objection.
But with no
you
objection,
cover
and that's how we would
yourself.
handle it. So, yeah.
See how wise that is? That goes back to the record. So Robert was thinking of the
Are you
record.
remembering who that is?
Yes, we know who it is.
Yeah, he's not on the
Oh,
planning
yeah.
commission anymore.
Remember that one. But if that gets
I think I
appealed,
was chair and I let it happen.
Yeah, but we asked about objection, so it was okay.
yeah, it is okay. And no objection, please then continue to participate. And building the record like that really helps, because we're always thinking of the judge that's looking at the transcript. Did they see that we did everything possible to comply with due process? So great response, good discussion. Let's go to a different.
Sure, I think this was the next scenario, and you already covered it, which was, this was
Well,
a
what is
site
it?
plan instead of a comprehensive plan amendment, and you live next door.
Oh, so now you're in a quasi judicial, it's a site plan application.
We got it the A+ answer already.
We did.
So next-
Well, let's see, may you discuss and vote on the request for site plan approval? What would your answer be? Now there, I don't know. What, can you still vote? The chair asked if there are any conflicts of interest with any item on the agenda. This is broader, and the site plan's coming up. Do you need to say anything? Who's got that answer?
At the onset of the meeting?
Yeah,
If it's anything on the agenda, you do have to say something.
if that's how the chair put it, is
Yeah.
there anything on the agenda that any member thinks they
You have
might
to ask
have?
that specific question. though.
Because maybe there'll be someone else as a chair, and they might ask that question,
Yeah.
and then how do you answer?
So, yeah, you have to say that whatever potential conflict of interest you might have, you have to reveal
Disclose
that.
it. Okay?
If you're a neighbor or kids are in school together or whatever it might be, you have to reveal it. And then you just say, but I think I can make a judgment that's not going to be biased in any way,
Excellent, excellent.
and then wait for response.
And if nobody objects, could you then vote on that?
Yes.
Definitely. And if somebody objects, that's what we just talked about, probably best not to. Even though some of them seem kind of silly. Are your kids in school together? I don't know, but it might depend on, you're voting on a school remodeling project, I don't know. But there might be contextual, where it sounds on first blush that couldn't affect it, but you look a little deeper and it does. So a lot of cases on this before we had the state statute passed that said as long as you disclose and no one objects, you continue to sit. And if you disclose, all of you, and there's objections, you can still sit because they have this thing, doctrine of necessity. You're going to have to make a decision. And you all really, maybe you don't like a certain individual, and you say, yeah, I've had my conflicts with this person in the past.
It might happen today.
It might happen this evening. You can still sit and vote because you can't all recuse and just have no decision. So that can happen. How about this one, Andrew?
Sure, so the planning commission this evening includes both a proposal to amend the comp plan on tree protection and a construction mitigation plan for a large remodeling project. You're a professional arborist, and one of your kids goes to school with a member of the family that's remodeling their home. We seem to get all the same.
Well, yes, because this is the stuff of life. It's what comes up.
There you go.
Do you have to disclose you're a professional arborist?
This is in relation to, I assume, the comprehensive plan amendment? Or just generally?
It's not clear.
No on arborist and yes on,
Yeah, I'd say no and yes.
yes on the kid goes to school with a member. And I might add, when in doubt, disclose.
Thank you. There was some listening. Yeah. Yeah. And again, it's unlikely anyone would object, so why not disclose it? That's probably the better thing to do. And in this today's world with all the information that's gleaned from all the social media, you may think nobody knows about, I don't know, your little private plot of land that you've been hoping to develop someday, and you've obscured it under LLC, ABC, and no one knows. You better disclose it because someone's going to know that. And if you keep it private and then it comes out that you do own that property next door, that's when the trouble begins. So yes, thank you. When in doubt, let it out.
And on this one, I think the more interesting issue is if you're looking at the construction mitigation plan, it may matter that you're a professional arborist because you may have very specific views on you know, what's appropriate and what isn't, and you're supposed to be serving in that quasi-judicial capacity where you're only looking at the criteria, you know, and when Ted or I are making a decision on a plat or whatever it is we're looking at, we're not supposed to bring in all this outside information. You know, Ted has so much of that from all of his very life experiences, but he's supposed, you know, you're supposed to focus just on those criteria. So anything that might impact your ability to focus on the specific criteria is potentially something you should disclose or at least think through.
And this actually brings up an interesting thing, because previously, 2 years ago, you guys talked about building the record. And so if you're an arborist on the planning commission, for example, I don't think we have anybody that is, but if you were, and you mentioned about the tree protection, about your role, about all of a sudden trying to act as an expert witness on the application.
Mm-hmm.
So anything you want to mention about that? Is that kind of a scenario?
Other than it could be very problematic, is that, okay, so, yeah, essentially if you're wearing two different hats, and one hat is I'm a member of the planning commission, and then in my regular life, I'm a professional arborist, and I have worked on maybe properties in the area, some of which may be impacted by a proposed tree ordinance, that could create major conflicts with potential liability and
On the application. Now, the comprehensive plan?
on the comprehensive plan, that's, I think, way less cut and dry.
Yeah, although you might welcome the expertise. because thankfully we do have experience on the Planning Commission. Each of you has a background and experience that should weigh in on the comp plan and ordinances where you're asked to advise the council. That's why you've been chosen for the Planning Commission, because of the variety of experience that you bring and the variety of perspectives you bring to the commission. So never hesitate to use your expertise when you're in that legislative role. But that's your point, quasi-judicial role, don't become an expert at that point, because then it sounds like you're taking sides. And then you'll be labeled as unfair. So that's where you disclose and avoid that problem. Well, let's sum up. Okay, we're all on the same team, Planning Commission, City Council, Hearing Examiner. We're all working on the same goal, which is to do good process, due process, procedural due process. In our decision making, we want to be fair and we want to comply with the law. And that's what we do in different ways. You do it politically when you're looking at legislative things, considering all perspectives. You do it legally when you've got an application in front of you. And like Andrew mentioned, then you put on the blinders. I'm looking at the criteria. I'm looking at what's in the ordinance for how we can decide, and that's what I'm going to stick to. I'm not going to go outside that. This is really tough for us sometimes on variances, because sometimes, and I think planning staff would corroborate this, sometimes variances, it's really hard to see what the special circumstance might be. But we stick to it, and there's sometimes creative language, in my opinion, used, but we get to it. It's a special circumstance. If it's not by any stretch of creativity, then the variance needs to be denied, even though you're thinking, it'd be so fair to grant this variance. I mean, it's just 2 feet in this corner of the house, and to take the house down, and it just doesn't seem right. But if it doesn't comply legally, that's all that matters. You can't bring in what you think would be the right outcome.
In quasi-judicial decision-making, we have no authority to deal in equity.
No, good point.
We are inequitable. We
Yes.
simply look at what the criteria are. So when you guys are looking at site plans or the construction mitigation management plans, you know, you're not thinking what's fair or what's not fair. You're thinking, what are the criteria?
That's right. If somebody objects, and Mr. Reeves, that's not fair, you might say, well, I'm doing my job.
Yeah, what I always tell folks is that if you think something doesn't seem fair, then you look at to change the law. You can't change the law as part of a permit application, but legislatively then is when you would look to change the law. If you think something is unfair, that's the place where you do it, not in the hearing for an application.
And to ensure that you don't ever get in trouble on the quasi-judicial ones, you know, I often teach a different class on writing decisions, but I would just point out, if you're always going back to the criteria and you essentially say, we decide this because, quote, you know, name the criteria has been met for reasons A, B, and C, you're going to have a pretty good record of why you did what you did. And it's going to be, I think, very defensible. So I always encourage any quasi-judicial decision maker to constantly refer back to the power that's been given to you and the criteria that you're supposed to address. It's not a very elegant way of writing things, and we struggle with that, but it is a very legally defensible way of doing things. So
That's a good piece of advice. And as you sit as members of the commission and you hear an application, just echo that. You might just say, you know, I'd like to vote to approve this. I've looked at the criteria and I think it meets each of the criteria. That looks really good on the record. It really helps support what the commission did. Now, if you don't believe that to be true, then you might say, I think it complies with 3 of them, but this 4th one I'm really struggling with, and I'm not sure it meets that criteria. But you can do that openly on the record will really help, again, anyone reviewing the decision to understand how you got there. When we write a decision, we're really trying to show a roadmap. And we'll do a lot of subheadings. Robert knows this because even if you read our subheadings, you will see the criteria there. So we're given a roadmap to the reader that we've addressed each one of those. That protects you from liability, and we hope over time helps establish credibility of your system. So as your hearing examiners now for some years, over time, it's really refreshing to us. You've got, in our hearings, a very civil community. And even when there's very controversial hearings, we just have to kind of subtly say, could you hold that comment? You'll have an opportunity later, or it's not in the context of our hearing tonight. You might want to go talk to your planning commission. They can handle that one. People comply, and they're very, very civil. And we really appreciate how that's, over time, come to be the tone of the hearings that we're holding. So we like our work in Medina. Anything you wanted to say?
One final thought on that, on what we were just discussing on defensibility, et cetera. When it comes to quasi-judicial, those few decisions that you're responsible for, I can only stress enough, or can't stress enough, it's not your responsibility and it's not planning staff's responsibility to show how a project complies with those criteria. It's the applicant. So never hesitate to say, you know, Mr. Morrison, can you very clearly explain for me how you believe this project complies with A, B, C, D, and E of the code? And if you're sharp like he is, he'll tell you, but you do see these situations where, you know, you have really competent planning staff where it feels like they put a lot of effort and time into something, and so you know they know what's going on, but never hesitate to say, I'd like to hear from the applicant and get their perspective on why they believe a project complies. Make them do the legwork, and I can't stress that enough. It's not up to, you know, it's not your responsibility to fill in all the gaps. It's their responsibility.
That's a really good point.
And I was going to know, that's why you'll see Christina, sometimes when you ask her a question, she'll say, well, I will defer that to the applicant to be answered, is because the legwork is to be done by them. They like to ask staff to support and do a lot of things, but that's one of my philosophies, is that the applicant has the burden. It's not staff with the burden, it's the applicant with the burden, and so you see us follow it. One other thing I wanted to note just too for construction mitigation, because since they don't see the final decision, but what you do see is in the staff reports, we actually do walk you through the criteria in here. So that's one of the things for you to have some confidence is we do walk the criteria through here. We do give you an analysis, and we also have conclusions and things, and a lot of that stuff is actually what does end up in the final decision. It's
You
just
have
that
the
we have to
proposed
modify it.
findings as well?
Yeah, and we just have to modify it based on what happens in the hearing, obviously, because that's the record that's being established officially.
But that is great for you as individual members. We urge you to be fully participatory. And this comes from some experience I have with the Washington State Legislature. I was legal counsel to a couple committees down there for part-time for about 5 years. And I had a legislator, after they voted a bill out of committee, come to me and say, you know, I've got some questions about that bill. Do you think you could answer them? And I was perplexed. You know, you just had a hearing, and you had an opportunity, and the chair several times asked, are there any additional? Oh, I know, but I didn't want to sound stupid, and so I didn't ask him. Free yourself from that. You will not sound stupid. And you've got a template. You can look at it and say, you know, I see this proposed finding that says it's 50 feet, but I know that property. I think it might be less than that. Can you tell me how you got? There's no dumb question at the quasi-judicial hearing stage. And the more you can show you really actively participated, we do that. We've got a lot of dumb questions, but we're not afraid to ask them because you're eliciting the testimony of the planner, or as Robert just said, more likely the applicant. Oh, we got that number from the applicant. We'll defer to them. Oh, we just kind of did a site and figured 50 feet. You're going to dig into some things. You might be surprised what you learn by going into that. So always ask questions.
And one of the things I've appreciated about working with Ted all these years, and Andrew as well, in more recent years, is the fact that even though there are supposed to be rules for evidence and stuff, you've always allowed actually very broad, for people to speak, to bring in broad amounts of information and then basically sift through it. So that then you focus on what the decision has to be based on, but you do allow, so that's why asking anything, you guys have brought this up before and you have a question, it's fine to ask the question. The key thing is then just knowing the distinction between whether it's part of the criteria or whether it's something else. So That's just kind of sometimes some of the fine lines, but allowing the record to be built as wide as possible, but then knowing that you have to sift it down and focus on the criteria for your decision-making.
Yeah, broad spectrum, but always relevant. And if somebody gets out of control and wants to talk about, there's too much government, I'm here to tell you, we need to, oh, I understand you've got a point of view on that. That's not why we're here tonight. We're going to focus on this. And we do get that. We do get that. Well, we never get the other side. Does anyone ever ask for more government? I haven't really heard that.
There's too little government in the city of Medina. I haven't seen that one.
I just say the old, who was that comedian that said, just be thankful you don't get all the government that you pay for. Well, okay, and then, well, here's the hook. Here's the hook. The hook's coming in.
Did anyone have any questions before?
Well,
we
listen,
let you move
it's
on?
been just under an hour, so thank you for your attentiveness. And yes, we will take any comments, questions, but again, it's good to be here, and hopefully we do this every year or two to meet the commissioners. And we're glad to know who you are, and thank you for having us as part of your team in land use decision-making here in the city of Medina.
Thank you.
So here's your opportunity if you have anything you want to ask.
Not really. I mean, kind of, we went through it and we were asked questions on our way.
Mm-hmm.
Mark?
I'm good.
Cool. I know you gotta have to have at least one.
Thanks. I always have questions.
Good.
Here's mine. So with regards to, there's an issue of, once the record's closed, there's no new evidence, but there's also an issue of following, what's laid out with regards to the city code and that kind of thing. What if, for example, there's evidence that's brought forward that could potentially bring in the interpretation of the code into question?
Mm-hmm.
How do you handle a situation like that?
And you're sitting as a commissioner and
Yeah.
you're hearing that?
Yeah.
Wow, I think just like you just did, I'm looking at the ordinance and I've got this information here. How do you interpret this? How does this consistent with, or how does it fall under this ordinance? Is that
Yes.
what you had in mind? Yeah, I think being really open about your own internal deliberations is really helpful. We do that as hearing examiners, and by the way, we follow a checklist. Everything we do, we have a checklist to make sure we're complying with due process. We have a checklist for writing our decisions. You probably have your own internal checklist when you're listening to things, and if something isn't matching up right, I think it's very good to be open about your deliberation, because I might say, just like you, I'm here applicant, I'm looking at the ordinance, and it says there must be no negative impact on the environment. Can you help me figure out why you can say that? Because it looks to me like you're going right into this stream. How do you come up with that conclusion?
Just so I understand the question too, you were wondering if you've already held the one hearing,
Yeah.
Oh.
and the
And then the new
record is
evidence-
closed,
yeah,
and then
so-
new evidence is later
Oh,
submitted.
okay, I misunderstood. Thank you for
Consideration.
clarifying.
Using
so-
the example of a stream or something, and that.
And it
is
wasn't there in the
determined later,
hearing.
But then you're
Uh-huh.
also realize, is this a potential liability for ourselves?
Got
Because
it.
there's new evidence introduced, and it might actually
So,
contradict what we interpret to be.
Got it. You become
the-
aware of that
Yeah.
evidence after the hearing's closed.
Yes,
and this is on a quasi judicial matter, I assume?
or,
I
Yes.
Well, I guess
The
you'll have
legislative's different.
You'll have rules potentially, I assume, the rules for how the planning commission operates. I don't know what
That's a
your rules
reconsideration.
are.
Well, but on a quasi judicial, once you close the record cannot be reopened back up.
But then the
Unless there's
commissioner
a
becomes
reconsideration.
aware, I went out to their property and there's a stream. Isn't that the new evidence
Well,
that
and-
wasn't
And
considered?
this gets into the question of a record because they're outside of the hearing, and if a commissioner went out to a property outside of a hearing and creates new evidence outside of the hearing, I believe there's a
It's
problem with
problematic.
doing that.
Yes.
Yeah,
If, for instance, after the hearing, let's say the applicant's attorney became aware of some evidence that maybe they were unaware of in advance of the hearing and the record's closed, then you can move for reconsideration.
okay.
And there may, in some jurisdictions, there's even, and I don't know right off the top of my head in Medina, there's some potential to even sort of preemptively do reconsideration
Reopen?
before a decision comes out. I don't think.
I mean,
there's a way to
reopen the
reopen
hearing.
in Medina, is
No, I mean, once you've closed and made your decision, reconsideration is
That's
would be the
good.
procedural route, yeah.
The reopen thing runs afoul, I think, of the Regulatory Reform Act, so
Right.
that's always a little.
Because the flip side of that is that you do run into the potential, somebody going out there and having a different interpretation about it, and so that's the other side of this, is that
Yeah.
so.
Well, that's a good question,
Exactly what it
and that's what you want to be thinking about.
Okay.
Yeah, and as you open up your quasi judicial hearing, this is the one opportunity for you to bring information to us before we decide. There's not going to be another hearing. There's not going to be a chance for you outside this hearing room to let us know what you know about this application. Now, you can really, and you can say that too as a member of the commission. I want to make sure that the applicant presented, is there any other fact that we need to know about this? And there again, that's the record where you're
Yeah.
building. And if they don't come forward at that time, you've done your job as a good planning commission member.
And again, in your role as a quasi-judicial decision maker, I kind of made the joke about Ted knows so much stuff, and he has
What? That was a
he
joke?
has to forget all that when he's in his role as the hearing officer. But this is applicable to the extent that you have to be wary of conducting all your own investigative research when you're being a quasi-judicial decision maker, because really your role is to hear the evidence that is being presented by the applicant, apply that evidence to the code, listen to testimony that other members of the public may have. But if you're kind of like, oh, I'm going to go check it all out on my own, that gets
You get in trouble.
yeah.
You get in trouble.
So
Yeah,
Well-
I think it's important to note that in your role as a judge, you're not, and I mean, this sounds kind of harsh, but you're not really there actually to protect the community. What you're really actually there to do is apply the law to the facts that are presented to you. And that should hopefully protect the community if the law is well-written and stuff like that.
we got Sue, let's go.
Well, I was first, and I'm the chair.
Sure.
I get to go first.
Prerogative.
I do try to drive by each of these construction mitigation plans. I try to drive by the properties more to get you look at the pictures and you can't, to see what's really going on and, how steep is the slope? Or, without trespassing, it's just what you can see from, as just a
And we do
passerby.
that too, to the extent that, it's a site view, but there's a difference between feeling like you understand where the site is and what it looks like versus, well, I was really concerned, I read the staff report and I went, I better go check this out, and doing a bunch of your own independent research outside of the exhibits that are submitted to you, that's where you're going beyond what is allowed. And
I would say it's helpful to do a site drive.
To
Yeah, it's in your community, let's just drive by this on the way to the hearing, whatever. And then you can put it on the record. I drove by that site earlier today and I saw this one area, it looked like that was, steeper than 30% slope. Can you help me understand that? That's great. And I would put, anytime you do a site view, I'd put it on the record because somebody observed you doing that. They had a drone up there and they knew you came by, and if you don't disclose, someone may attack you on that basis. There's all sorts of ways to attack a decision that somebody doesn't like. So why not just say, I drove by earlier today, or even to confirm, and I saw what you're talking about. I saw those 2 trees right along the driveway. So are those ones you're talking about? That's okay to do. It's a good idea to do that.
It can help you formulate your questions for the hearing.
Yes.
It's just what you want to be careful is not to all of a sudden start substituting, because you went out there and start substituting you as the expert versus.
Right, or
everything
talk
else
to
in
the
there.
applicant. You don't want to
Right.
have any conversations.
So my question was basically what you just reported. I just, that we need to report that we either drove by or that we talked to the applicant or to the owner. Maybe it was by accident, you just drove by and somebody said, hey, what are you doing here? You say, oh, I'm with the planning commission. Oh, well, So we have to report any contact that we have with the applicant or staff or the owner. And is that, can somebody object to then you being fair with that information out
Yes,
there?
yes. I don't know what you talked about.
Okay.
And I really don't like this proposal, and thank you, Commissioner, for disclosing that. I object to you sitting on this because I have no idea what that conversation was, but it makes me uncomfortable to have you sit there and decide after you had just a dyad, you had an individual conversation with the applicant. I'd ask you to recuse yourself. And I think you probably would. Do you have different advice on that?
I would advise that you probably should in that case,
Yeah. Yeah, and that, frankly, that's why there's hearing examiners, because you will run into somebody at the post office or at the store, and they will want to talk, especially if they know the application's coming before you. And this is when I used to go to council members, because WCA, they had a guy named Mike Walter, I think he still works with them, and he'd scare everybody on the council about, you're making these decisions, let me tell you, if you make it wrong, you're going to get sued, and we're probably not going to help you. Now, we got Ted Hunter here who's going to tell you what you can do to get out of that quandary. And I just talk about the hearing examiner system. And council members couldn't believe it. You mean if we give you the directive to make decisions, then we can talk to people about it? Yeah, you sure can. And you can come to hearings. Planning Commission member, we'd love to see you at a hearing that you have some information on. That's very fine to do if you have a feeling.
Testify?
Definitely testify. Yeah, if it's an application you have an interest in, we definitely want to hear about that.
But what role are they testifying in?
Well, it's difficult if you get into legislative history. You know, we would listen to it. I've had this happen several times. You know, I was on the commission when we passed this ordinance, and I think what we were going to try to do with this ordinance is this. Thank you for your testimony. That's one out of many. It's not going to carry a lot of weight. Might be helpful. Somebody else might have a different view, but it's okay. There's no rule against it. And you'd be very welcome in our hearing room, which happens to be this very room.
Sometimes.
Yeah.
Most of the time. Every once in a
other
while.
rooms, bigger
Yes,
rooms,
we have.
smaller
Oh,
rooms.
that's true.
Bigger rooms, yeah.
Yeah.
Sometimes during a hearing, we can digress into areas of irrelevance, and we can stray from the diligent construction of the record, even heaven forbid, lose our scope of authority.
Mhm.
How can we, as a group, get back to, and maybe this is as a group, or maybe it's from a chair or vice chair perspective, how can we get back to these central ideas? Can you give us some
I see a
practical?
gavel coming up. I
Can you
think
give us
that's-
some practical suggestions?
Well, is it a shared value? You know, do you want to stay on the business you have to do on the agenda? You got to commit to that. And that might even be a way to go through. I notice you go pretty quickly through, well, here's our agenda. You might, you know, is there anything you want to add to the agenda or remove? Does everyone agree that this is the agenda we will stick to tonight? What we do in announcing our hearings, particularly if it's controversial, we will set some ground rules. And that might depend on what you sense as chair, what the room's like. But the ground rules are, can everyone agree that their testimony will be on the topic before us tonight, which is a request for a shoreline development permit for this specific project? Thank you. Can everyone agree when you speak, you'll do so civilly and concisely so everyone gets a chance? So you can set ground rules for the audience, but also it's for yourselves. So we've all agreed to this agenda. Can we agree we're going to stick to the agenda, because I know there's a lot of other ideas out there. We're going to have time for that at a retreat or a work session, but tonight we've got a lot of things to decide on our agenda. And that helps, and you come back to that and say, I want to remind you we all decided. And then keep each other on track. And certainly your staff, you want to welcome when they say, can I remind you, the topic that we're discussing right now is, what are we discussing?
Well, and if it's members of the public testifying, for instance,
Yeah.
one technique is to say, you know, I understand your concern with such and such, reminding you that, you know, what we're doing here tonight on this construction mitigation plan is addressing these specific criteria.
Right.
So if you can limit your comments to how the proposal meets these criteria or not,
Right.
You kind of focus people in, because you're kind of indicating
Yeah.
that extraneous information we
Yep.
understand you're concerned with, but it's not going to impact. what
And
we're
you
doing.
look really smart, and you're complying with law. There's another case, Marantha Mining, where that's exactly what happened, and the people testifying went way outside. And the court said, that is a hearing room out of control, and we are going to vacate that decision and send it back, because we can't have a decision be based on that kind of behavior.
What about limiting the number of audience participation or people either supplying information that is in opposition or in approval of a case. Can the chair say, okay, if everybody here is in support of this, and you're all gonna say the same thing, I only need to hear from one of you. Can you say that versus the 10 that are there to?
Yes, yes, you can.
Okay.
Yeah, the only thing you don't want to do is, okay, let me see how many hands in favor, okay, now how many opposed?
Okay,
Yeah.
can't do that.
Well, you don't
Well,
want to, because
that-
for
that-
one, you're setting up conflict immediately. And part of when it's a quasi judicial, we don't yet know what the applicant's gonna say. And so maybe members of the public are concerned with, oh, I'm concerned about trucks coming by my house at this such and such time, blah, blah, blah. And the applicant might come up and say, I didn't know that was a concern. And I'd be happy
To reroute them.
to reroute or limit. And then, but if you set everyone up in advance as a pro and con, you're just asking for
Yeah.
there to be no compromise. If you set it up, kind of get through. But what I'll say in advance, if I know there's going to be controversy, is I'll say to the public, this isn't a situation where 30 people being, supportive and 3 people being against it. It's not a balancing. We ultimately decide based solely on the criteria, and we're very interested in.
Are you saying it's not a democracy? Is that what you're saying?
It's not.
Yeah.
We're very interested in concerns members of the public may have, but
Yeah.
if someone has already testified to the concerns that you had, don't feel obligated to come up and
Right.
repeat those concerns, and you kind of lay that out in advance.
Do you have people sign in? And do they say in favor or opposed?
No.
Typically, sometimes it will say support, but typically.
You wanna
they'll just say
remove
what
that.
But the form doesn't say that.
The
That's-
form
that's-
doesn't say
no,
that.
that's if they
Someone
want.
might write that in.
They volunteer.
But you would believe how many cities have that on their sign-in sheet. In favor, opposed. And it's just not a good idea. That's your point.
Yeah.
But yes, ask. I see there's 10 people have testified. How many agree with what that speaker said? That's okay to do.
Well, I've also seen I've seen you did this in a hearing where there was a lot of people and you're saying, well, if I get the testimony, that's really what I need. But then if you've got just the same thing and want to come up and say ditto, and I've seen that done. And
I agree with some.
and yeah, and then they feel like they're heard.
Yep.
And you don't have to necessarily spend another 5 or 10 minutes or whatever the time frame is hearing the same thing again.
Right. Laurel?
Oh, thank you. Thanks. This is the first time I've heard this presentation, and it's been very, very helpful. I appreciate it. My question, I think, is in the realm of scope of authority and also procedurally in the hearings. So from what I understand, the burden is on the applicant to demonstrate that criteria have been met. From what I've seen in my experience so far, staff typically weighs in on whether or not the staff makes a recommendation as to whether or not they believe the criteria have been met. Criteria are often expressed in terms of things like reasonable something, or they're not always well specified. So given this one hearing scenario, if as a commissioner you don't feel necessarily convinced based on what's been supplied to you in the proceedings so far, or if you think that there something else could be done to better demonstrate that the criterion has been met, is it within the scope within that hearing of you to ask for that information, or do you have to make the decision based on the information that's presented?
Ask for it, and just the way that you're indicating you would. And a good phrase for you to use is substantial evidence. You're right, there's a whole lot of measures. It's not beyond a reasonable doubt. You're not in a criminal context. Preponderance of evidence, but substantial evidence is a good, safe one for you to use as planning commissioners. I'm looking at these criteria, and I don't think there is sufficient evidence, or I don't see substantial evidence that supports this particular finding. What's one out of your, I don't know, construction management plan? I don't know what they are.
There's a whole list.
Just one.
I remember I've done
There's too many of them, but you just pick one that you're not comfortable with.
Parking.
Adequate
Parking. seems to
Parking.
be the-
I'm not sure I see enough evidence about parking, and I'm uncomfortable saying yes or no until there's more evidence presented on that specific issue. And then the option for chair usually is to continue the hearing or leave the record open. Those are two choices. You don't necessarily have to come back to hearing, but a sophisticated applicant would say, well, I can present more information on that. I can do that within the next 2 days. And you can say, all right, we're going to keep the record open for 2 days to get that information. And that's one way to handle it. But yes, whenever you feel, I don't think I have enough, make that, I don't see sufficient or substantial evidence to support this finding.
Right, but the key thing is, again, it needs to be tied into the criteria, because I have seen it happen before in conversations where things that are not part of the criteria get brought up, and people then will, and the conversations will happen around that, but it's not actually part of the criteria.
That's why you have city attorney here, that's why you have Robert here, he's going to let you know if you're not. That's why I asked Robert, what are one of the criteria? He knows them, he's working with them all the time.
Any other questions?
Well, then, again, thank you for your time. Earlier, Robert interrupted the applause, and as a performer, I really like applause. I haven't been on stage for a while. Thank you, thank you.
Thank you very much, that was perfect.
Public hearings.
So, yeah, this is the nice thing, you just had some quasi-judicial training, and now we actually have a construction mitigation plan for you here tonight. So Sean, it starts with you.
Well, wouldn't these be appealed to us?
Well, he can start doing the appearance of fairness and stuff here, so.
Well, I'm saying we should get out of the room.
Beat it.
Right.
That is true, yes.
I'm being serious on that.
Yeah. If you make a wrong decision, the hearing examiner is the appeal body for that, and so they can't actually be around for this discussion.
Thanks, Ted. Thanks, Andrew. That was all.
Thank you, everybody.
Appreciate it.
So, yeah. Yeah, that's the same thing like an ex parte, so they have to avoid whenever they have something that's potentially in their line, they also have to avoid anything until a hearing actually happens.
I think so. We'll see.
We consider this their dawn?
What's that?
Close enough?
Yeah, well, it's going real quick. So did most of you find that I mean, when we did it before, everybody found it useful, but I think it'd be good to ask the question again tonight, because we have new people tonight. Did you guys find that helpful in kind of formulating? Because
And having a couple years.
quasi-judicial is very different, and there are certain rules and stuff you have to be careful about, but it's also, as he mentioned, don't be afraid to ask questions, and if you're not comfortable, it's also perfectly fine, this has come up before, you can hold a hearing open for additional testimony, there's nothing wrong with that. Also, I forgot, I made a mistake, David did email me and told me he couldn't make tonight, so there was actually, I had something on, I just forgot about it, so I apologize for that.
Motion to excuse,
Motion, so moved.
Second.
all for,
Aye.
opposed, excuse it, please. Here we go. See if I can read it through this time. This is a public hearing for a tailored construction mitigation plan for Mark Nicholson Architecture. The proposal is to redevelopment of residential lot, case number CMP 17-027. The project is located at 2021 Evergreen Point Road. This is a quasi-judicial matter, and thus the appearance of Faulkner doctrine applies. I will first ask if any planning commission member has any disclosures related to the appearance of fairness. Mr. Nelson has raised his hand.
Since I'm the applicant and the architect for the project, I am going to have to recuse myself.
So show Mr. Nelson is recused. I will also disclose that I drove by the site just to see for visual purposes. Anybody else have any disclosures?
But you can be fair and impartial
Oh,
in
yes,
your
I can
decision.
definitely be fair and impartial.
Okay.
I know Jason Williams, who may or may not be affiliated with the project.
Yes.
Sad Custom Homes.
I did want to say that Jason will be representing the client tonight and making any question, or making a presentation if necessary and answering questions?
I know Jason, but I don't believe that will affect my position of fairness.
On the basis of these disclosures, or for other reasons, does the applicant or any member of the public wish to challenge any member of the planning commission? Okay, good luck.
See you later.
The hearing will be conducted in the following manner. First, the staff will provide a summary of the report, of the staff report and their recommendation. The applicant and their agents are then allowed to provide any additional information and ask any questions that they might have of the staff. During these presentations, commission members should ask the staff and the applicant any questions they have. Following this, the public will be given an opportunity to speak on the matter. There's not a lot of people, but if there seems to be a lot of questions, public testimony may be limited to 3 minutes per speaker. Following the closing of the public hearing, the Planning Commission will then proceed to decide the matter. Are there any questions? No questions? Here we go.
Swear to tell the truth?
Yes, I do. All right, so.
For the
before-
record, your name, please.
My name is Christina Hayworth. I am the city's planning consultant.
Thank you.
And for the record, I do have a correction. Laurel pointed out to me that I had mislabeled Exhibit 5 as Exhibit 6. So that is this
Nice catch, Laurel.
file. This should be labeled Exhibit 5. It is referenced as Exhibit 5, but in the packet, it is labeled Exhibit 6. Exhibit 6 is only the construction mitigation site plan, and it looks like this. Okay, and then I also have one new exhibit to enter into the record. We received a written public comment yesterday, and I'd like to enter this into the record as Exhibit 10.
Exhibit 10.
Exhibit 10,
That's it.
that is what we
This is the
received.
complete document.
It is.
I actually asked that exact question.
She did.
I asked if there was a second side or any additional context. That is what was received. So, there it is.
When we get into the hearing, if you have a question about it, I'll answer it there later into the hearing.
All right, so the applicant has proposed a Level 2 tailored construction mitigation plan to redevelop the residential lot at 2021 Evergreen Point Road. Oh, one of my monitors is out. Okay, well, it's between Northeast 24th Street and Northeast 12th Street, and it's on Evergreen Point Road.
Since I have some monitors, a lot of issues, is there no way to get that one up, or is that something quick, or
If
just?
I hit this button, it's gonna put them all down, and they might all go down. So I'm not gonna hit that button, but I will go wiggle it and see if that works. Okay,
Please, thank you.
we'll wait.
The other thing we could possibly do is put both the aid in your head on this.
We are talking about getting new technology.
Can we just put that one against the wall and?
We're good. Does everybody see?
Can you guys see that? Yeah.
That's perfect. Thank you so,
Thank you.
that's great.
Okay, all right, great. So it's right on Evergreen Point Road. The south side of the property has a private lane that accesses or provides access for all three properties between Evergreen Point Road and the water. The scope of work includes demolishing the existing residence and constructing a new 7,584 square foot single-family dwelling with attached 2,839 square foot garage and 784 square feet of decks and patios. Site grading up to 5,000 cubic yards of earth and removal of 22 significant trees. The property, nope, I already said that. The level 2 CMP is triggered due to anticipated construction costs exceeding the 2016 annual threshold and the total quantity of excavated soils exceeding 2,000 cubic yards. Here is an aerial of the property as it's currently developed. The primary structure is this single-family residence. There's also a small shed down here in the southwestern corner. The property slopes from west to east at an approximate 9% grade, and mature vegetation grows around most of the perimeter of the property. It provides a pretty solid site obscuring screen on the northwest and south sides. The existing residence, driveway, parking area, and shed will all be demolished, and a new residence will be constructed in approximately the same location. The circular driveway will be slightly reconfigured, but the current access points will remain the same. The applicant will use all 3 existing entries as construction entrances during the project, and I'll get into that more in a couple of slides. The applicant will be installing tree protection fencing around the significant trees that are to remain, as well as the hedges along the west and south property lines. The existing vegetation is sufficient to screen the property on the west and north sides, but 6-foot-high opaque construction screening fencing will also be installed along the north side of the private lane here, and along the east property line against Evergreen Point Road. Okay. So the applicant is proposing to use the southwestern entrance, this one here, as the location for the job shack and 1 parking stall. And this is also the location where the boom truck used on the project will be deployed. It'll be delivered from the private lane and operated from the pad in front of the home. The southeastern entrance will be used primarily for accessing construction worker parking and servicing the dumpster and portable toilet. On a typical day, construction workers will park at this entrance and it will be gated closed until they're ready to leave for the day. But in cases such as excavation, when driving through the lane is necessary and the dumpster's not in place, there's 10 spaces reserved at Christian Science Church in Bellevue, and trucks will be able to enter and pull directly through without having to back out onto either the private lane or Evergreen Point Road. Large vehicles will access the site from the northern entrance. The vehicle staging area is on the straighter part of the lane in the center, the circle drive in the center. Material and equipment delivery, with the exception of the boom truck, will occur at that location, and then materials will be transported to the material storage area, which is just on the north side of the private lane. So here's the location where the boom truck is going to be deployed again, and then there's a 70-foot operational radius for the boom that has been demarcated on the plan. And it will be operated such that it does not encroach into the airspace above neighboring properties or the right-of-way or the private lane. The applicant is proposing normal arrival and working hours, 7 a.m. to 7 p.m. Monday through Friday, 8 a.m. to 5 p.m. on Saturdays, no work on Sundays or holidays. This is all consistent with the hours set forth for construction activity in the noise ordinance. Private lane. So I asked a lot of questions about the private lane. They are planning on using it for some construction-related activities. So there will be infrequent closures to service the dumpster or portable toilet. They are required to provide a minimum 24 hours notice to affected property owners, and they estimate that this will occur approximately once per week or less. Delivery of the boom truck will require temporary blockage of the private lane while it's offloaded and moved into its location for, or its operational location. And then paving of the lane will occur after construction is complete, and that's a minimum 48-hour notice requirement for affected property owners. The applicant agreed to install a sign saying that parking or blocking the private lane is prohibited, but because they're proposing to use the lane, we've asked them to modify the language to state that it is a violation to park on, block, or obstruct in any manner the private lane without expressed written authorization from the superintendent. So this would prohibit parking or blocking the private lane normally, except when a delivery or service vehicle is expected. And then they are also required to keep flaggers available on site for any and all backing maneuvers. There's a significant amount of soil export happening with this project, approximately 5,000 cubic yards, which is about 1,000 one-way trips in single-load 10-yard trucks. They are proposing the use of 2 routes, primarily due to the construction, the 84th 24th project, and the impacts that might have to the intersection of 84th and 24th. So an alternate route to use 12th would allow them some flexibility. Their temporary erosion and sediment control plans are still under review under their grading and drainage permit. Their tree removal has been approved under 2 separate tree permits, and then their building and demolition reviews are also still pending. Those are with Steve Wilcox right now, so they've passed zoning review. Staff recommends approval of the construction mitigation plan, subject to 3 conditions in the staff report. Are there any questions?
We always start with you. Well, I'm normally not the tree police, but it says there's 2 tree permits on your level 2 tailored construction mitigation plan. This one says removal of 31 on-site significant trees, and on, it looks like the newer page, it says 22 significant trees.
Yes, so the original numbers I took off of their application that was originally submitted. It's since gone through revisions, and I checked with Tom to get the approved number of significant trees to be removed, and that is 22.
Do we need to amend this, or?
The project
It's
description?
the notice of application, level 2 tailored construction,
No, you don't need to amend the notice of application. That was the original scope of
Okay.
work. So, and that's not really part of the construction mitigation.
Then the kids in school, we look like we had that covered again with the trucks, not idling,
Right.
school times.
That information was provided. So Exhibit 8 and 9, I believe, include information on bus stop locations and on vehicle idling. Let's see. So general information on trucks and the truck haul routes, as well as vehicle idling and temporary erosion sediment control clarification is in Exhibit 8. And bus stop information is in Exhibit 9.
How do they, you brought it up, so you probably already mostly answered it, but let's just go over it. This option during 84th, 24th project closure, there's gonna be a certain amount of time there's a lot of use of 84th. Is there 12th? How are they gonna get all the way around? Are you gonna go,
So trucks exiting from 12th would be routed through Bellevue
okay,
and headed towards 405.
it's just, it's a lot of trips. I mean, like you're saying, 1,000 trips is quite a few.
It is a lot of trips. There is a significant amount of grading, specifically export for the basement on this.
But that's basically 500 trucks.
Right.
Yeah,
Total truck trips.
yeah, so 1 in, 1 out, 2 trips. So, yeah.
It was just, do you have a contingency plan? Because that area, it looks like they're all gonna try to be in at the same time.
Yeah, most of the trucks will be there during excavation, and it'll be kind of an in and out.
Not that, I know the trucks and excavation, I'm
Oh.
saying the excavation and the 84th project, I believe are gonna be concurrent.
Yeah,
So you have a contingency plan?
Yep,
Is-
they're planning on rerouting traffic south towards 12th for that.
The rest of it's pretty much code. You're doing much better than, we don't have as many questions. Randy?
Do you feel you've provided adequate notice for the project?
Yes. We followed the city's noticing procedures to provide the notice of application with a 14-day comment period, the notice of hearing with a 15-day comment period. It was mailed, posted, and I'm sorry, I don't have the affidavit of publication. That gets mailed back to us, and I don't always have it in time to put it into a packet, so, but it was published.
I would also just note that we actually exceed the minimum requirements whenever we do noticing, because we do post, and we do more than just post, we publish on our website, we put up on the noticing boards, as it indicates in here, which is actually beyond what our codes require.
Regarding the Santa can, I know it's shown on the exhibit, and maybe this is a question for the applicant, but is that the best place for it in terms of the least visibility for contiguous properties?
As far as visibility, I would defer that to the applicant.
Okay.
I would note that this location is very easily serviceable.
Yes, I see that. No further questions?
My question's about the dumpster that's on the private lane. Somebody said there's no dumb question. Is that the dumpster that will be, you're gonna have demolition of the property, so there'll be a lot of stuff. Is that going, I mean, you said, so is there other material that will be removed beyond this one dumpster? Because you said it's infrequent, and I would think initially it would not be infrequent.
So I'll just clarify that the dumpster is on the driveway, this portion of the driveway. So the private lane is along the south property line. So the dumpster will be serviced from the driveway, but it's physically placed on the property, maintaining access.
I didn't read it that carefully.
As,
I'm happy to answer that.
okay,
I think I understand.
you can come in
It
and.
was convoluted, sorry.
You want to raise your right hand?
Jason Williams?
Yeah, you swear to tell the truth?
Yes.
And for the record?
Jason Williams with SAD Custom Homes. I believe your question is the demolition of the house and whether that dumpster is going to be used for the debris from the demolition, and it is not.
Oh, that's okay.
The dump trucks that are going to come in and out for the demolition of the house will come, load, and go.
On the property.
This dumpster that's shown on this plan is specifically for just weekly debris.
Okay.
So that's what that dumpster is for. It will get serviced approximately once every week.
Is that 1,000 trips with trucks, including the demolition, or is that just?
It is, yes. So, and then the dumpster that we'll have on site is a 30-yard dumpster. It's going to last 1 or 2 weeks in its service life before we empty it.
Thank you, that helps.
I would actually clarify, I don't think that the numbers we use is actually for the dirt movement, so unless you're going to be using less than
It's-
5,000 cubic yards of dirt, then you would
The
have
numbers that
a few
we-
more.
The numbers that we put in for the dirt are an accumulation of the actual export, the strippings, the soil, the initial demolition of the construction.
Okay.
So, we have a professional service that does that for us, and the numbers that we gave you are appropriate to those numbers.
Jason, can you address the Santa can question? Is it?
The Santa can is
So-
always the bane of our
sometimes those,
existence.
yeah, I know. Sometimes
So
those are really
It has to be
visible.
somewhere within 25 feet of a serviceable space. So this space makes the most sense in the sense that it has to be serviced once or twice a week. In its visibility from Evergreen Point Road, I would say it's, we could fairly camouflage that. The occupant of this property and the one beyond it, they're going to see it. We can camouflage net it. We can do some other things to screen that facility if that's of concern of those prior
Would
owners.
if we put that into the our motion, would you be willing
I'm happy to buy a camouflage net
abide
and-
by that? Yeah.
And
So it's something
screen it the
simple.
best that we can with literally a netting or some sort.
Okay. Thank you.
So it's not bright blue.
Thank you.
Jeannie?
All right.
Run 'em all.
Is this the only time for questions?
No, we
Okay.
go around a couple times, go ahead and.
Well, I know that Robert had mentioned more information potentially regarding.
Yeah, if you have a question about this, that's part of the staff questioning, which is what you're doing right now. And then
Okay.
the applicant will have a chance, and then you'll have a chance for more questions to the applicant.
Okay, got it. So along the lines of, I guess, the dumpsters and the Santa can, so there's notice to neighbors of 24 hours for the dumpster, 24 hours for the boom truck, 48 hours for paving. That's somewhat short notice for mail. How is that notice delivered to
So-
the affected neighbors?
What we've recommended in the conditions of approval is that at a minimum, it has to be a written notice provided to those property owners.
Okay.
And that is condition 3, 3J and K.
So I know like some residents might not check their mail every 24 hours. So I don't know if there's a provision with regard, if we could be more specific in regarding what we consider a written notice, perhaps like including a paper posted to the door or something like that, because I worry that like 24 hours notice but delivered to the mailbox, and if the person's checking their mailbox every 3 days, that notice is basically moot.
Sure.
Yeah, okay, please.
So two things on that.
Yeah,
One is our plan would be a written notice to the property owners beyond us on the private lane of a regular schedule.
okay.
So it's not going to be something where every week we're like, it's Wednesday at 10.
Got
It's going to be Wednesday between 10 and 12 every Wednesday. That would be our goal for our written notice. The second thing is that our owner that we're building for also is the third person on the lane. So we really have one person that we're really noticing because the person that we're building for owns the property at the end of the lane.
Okay,
So, so it really is one person that we're noticing to keep that lane open, although we will keep it open for our owner as well. So I hope that makes sense.
yes.
Okay.
I have a second question, and I guess it hits upon this letter as well. There's along the lines of people checking their mail, and like there's a statutory, I guess, notice period of 15 days to delivery by mail. But we received this today, so I was just wondering, is there more information regarding, like, did this person not hear about it until recently? Perhaps because they don't check their
No,
mailbox every day?
it's not
Or-
uncommon. People get their notices, and it's not uncommon for us to get comments, written comments, even the day of or the day before. That's not uncommon.
Okay,
Yeah, we even, like on our shorelines, we'll have 30-day notice, and we don't hear anything from anybody until the very end. That's just what a lot of times, a lot of people wait till the end for whatever
Okay.
reason.
and I was just wondering if you could provide more information about the complaint, because there's, like,
Yeah,
there's potential verbal communications that occurred.
well, so this Barbara Cole
Yeah.
came in yesterday to the front counter, and she was going to be out of town, and she wanted to get something written, and she actually wasn't even sure which notice. She said she had gotten a notice, she couldn't even remember, so we went out and looked, and she identified it because it was something that didn't have a site plan on it. So she identified it was 2021, and she remembered when she started reading it, it was 2021. She just simply said she wanted to protest the development. That's all she had to say about it. There wasn't anything else more to it.
There's just, when I did my house, there was someone that just said, we protest, we just don't like development in Medina.
Yeah, I think she made a comment about mega house, which is not really part of the CMP process. That's something totally separate, but yeah, so that was essentially, and I think she indicates you may see more comments from her on future projects too.
Okay, I was just wondering, where on the map is her, like, is she directly affected by the property?
I can pull up the a map really
I believe she's
on 77, so
she's on 77.
Yeah, she's all the way over by,
So she's not contiguous, whether she's
79.
within
She
the,
just, okay.
I'm
just
78,
general.
77.
she may not be
Indian
within the 300-foot
Indian
radius.
Trail,
Okay,
2033.
Right, but I mean,
Behind it, just-
anybody that lives in Medina is going to be somewhat affected because of the trucks on the road,
Yeah,
but
that's my final question, really. I wanted to get an idea of, number one, when is the actual 84th Street expected to last? Like, plus or minus, with some, buffer in case it goes over? And also, how many projects are set to occur, like involving demolition and dirt removal that require, 1,000 truck trips around the same time that 84th Street will be occurring? Because that by itself is a pretty big impact to the community.
Yeah, so I can answer the first part in that, and I've mentioned this before, the project is scheduled for the contractor can start work as soon as the end of April, April 31st, I think it is. And then
On
is
this house, or on 84th?
no, 84th.
Okay.
And then the project is to be completed by, I believe it's early or mid-November.
Okay.
That's the time frame the contractor has. That doesn't mean they'll start on the end of April. They may start a week or two later into it, but that's the time frame that they have according to their contract. As far as the number of projects and stuff, that's actually not really totally possible to predict because we still have applications coming in that are going to be coming in through the course of this. And I do not have a count on the projects we currently have in. And of course, projects have different timelines when they need to be on the road because, and Jason may be able to say more about this, about their schedule. You have the period, like when you're doing the demo and when you're doing the grading and the framing work, and then once you get past that, it really kind of starts to slow down. You don't really see a lot of truck traffic. It's more just the workers coming in and out. And then at the end of the project, you'll see the mad rush of, the carpenters and the finishers and stuff like that is typically what we see. So even with all these projects, their timings will vary as to when they're actually going to get their work started. Because even after we issue a permit, some of them will go right to work, and some will wait a couple of months before they get started to work. So there's no way to actually give you numbers. It's really will vary.
There's also really wildly varying amounts of export and
Yeah,
like
of
what is
course,
getting
of course.
demolished, so it's.
But, like 1,000 round trips is pretty substantial, and like the 84th is such a major thoroughfare. It's like one of
Yeah.
3 main roads in town.
There are very limited options for
Yeah.
people, and 84th is on, I think, all of them but one. So,
I'm happy
Yeah.
to address the yardage counts
Okay.
and some of that and the timing of the export. So as discussed, the yardage that is being discussed is a cumulative total. It isn't necessarily all at one time. So as this project does get underway, there'll be soil strippings, there'll be tree removal, there'll be the demolition, and then the excavation. Those do happen typically in concession, but then after beyond that, the import, the backfill, the things that happen after that. So it happens in 3 phases. And that spread on a project of this size and magnitude is probably over, I'll say 4 months.
Okay.
So it isn't that we're running 500 truckloads of soil out at one point over a 2-week period. It's the fact that we're demoing over 2 to 3 weeks. We're stripping the soil, we're taking the home down, we're exporting that dirt or that material and those strippings out, the trees, the things that we're taking down out. Then there's kind of a lull, we stake it. Then we do the mass excavation, which is probably the bulk of where the consolidated truck routes are going to happen.
Okay.
Once that happens, then there's another big lull that happens between the truck traffic coming back to do the backfill and those type of things. So it's not 500 truckloads at one time. It is spread over probably 3 phases, and that phase is probably close to 4 months.
Does it happen to be the same 4 months?
Well, unfortunately, April to November is a long period of time.
Yeah.
We do plan to start this project during that phase.
Okay.
And we've shown our truck route appropriately to try to accommodate that because we don't know when that's physically going to happen. We have gotten notice from the city. We've got the information of when that's going to happen, and that's why we are showing 2 truck routes and not 1.
So if you come in on 12th, then you're not even going to be using 84th other than the crossover it.
Correct. If the construction is already going on 84th and we can't go out north, then we will be using 12th, for sure.
Randy?
Jason, how long will the mobile crane boom truck be on site?
The crane will only be there during construction activities of the framing. So our framer has a crane. He will have it on site for that period of time. We will bring a crane in to offload the concrete panels. That will be a one-day occurrence. Panels go in, foundation will be formed, the foundation poured, foundation panels lifted back out with a crane. So that's a two days during the foundation phase. Our framer does have an on-site boom truck, which is this radius that you see here. It will be on site the entire time. It will not be in the air unless we're moving beams or something that he needs it for. So I would probably care to guess that out of a 40-hour work week, that the crane's in operation 2 to 3 hours a week.
What is the duration of framing?
On this home, probably 10 weeks.
Thank you. Yeah, my concerns about using 12th Street, I appreciate the information about the truck trips being spread out. 12th Street is a little bit of a concern as a route because it going right between a park and a school. And I don't know if it's reasonable to limit the hours of the day that, you know, if you have to use 12, that it's used, or...
It's actually limited by the construction mitigation plan itself and its nature.
But, I mean, more to, you know, in school hours, so that, you know, when the park is more heavily used or something like that, it...
So we've addressed the mitigation plan requirements of the school bus stops and then the school timing of when school starts and stops, which we all know is very busy.
Right.
Especially at the five-way interchange that happens there.
Right.
So beyond that, we haven't really limited anything for the park per se, because I don't really think there's any data that I know of that we need to work around or have in when the park is busy or not. I will have to say that even though we've applied for 5 days a week during the business day, you know, business week, and then Saturdays, it's very rare that we work on Saturdays. So our time frame of construction would really be Monday through Friday, and I know that's school time. If we're going to start in late April or middle of May, there's going to be some time that we're going to be in the same time as the school is still in operation, but there's also going to be that bulk of that dirt that I talked about being removed from the site is going to happen during the summertime. So there's also that, and we can't guarantee when our permit is going to be issued or, you know, or that, but I just, in our approach, that's our hope, because if we are limited to 12 and we're limited to the hours that we have to be for school bypass, in reality, the best time for us is summertime when the school is not as active.
I would also just note too that honestly, there's no way for us to enforce, other than we have the hours in general, there's no way for us to actually enforce, because those, as far as where the trucks would be on, from their project to be on 12th, because there's other projects out there, and these trucks get intermingled, and there isn't actually no way for us. I mean, they could self-enforce, but that's the extent it really could happen on it. So just to be aware of that we don't have the resources to do that, to be doing that.
Yeah. There's, I mean, we already know there's another large project up 84th, right, that we did a hearing on a few months ago. So it's all coming together, and I appreciate how aware you are of the context and the conditions, and would just ask you to be very mindful, because actually I think in some ways summertime is maybe a more dangerous time from just a kids playing point of view than school time is, because it's unstructured and it's, you know, unpredictable and all that. So just for everyone to be.
I understand that
really
principle. The amount of traffic that does happen on 12th around the school there during school hours during, especially in the mornings and the afternoons, is pretty heavy. And so we're very conscious of that. You know, we do build in the area quite extensively. We're aware of the surroundings. We're aware to not have our trucks stage in town and just sitting around and sitting on the sides of roads and stuff. We do the best that we can to control that. It's not perfect, but we do the best that we can.
Thank you. Yeah, yeah. In the summer with more casual users, you know, kids dart around a little bit more, or parents crossing roads and all that. My second question is about utilities, and well, just ended up being a little confused as to whether or not utilities will be shut down and how often, and some of them are undergrounded, and if you wouldn't mind just giving us a quick summary on that.
The only utility that typically gets shut down on a project of this size and location is the power. So, or water. So those are the two. We will be upgrading the meter, so there will be an 8-hour shutdown for the meter when we go to replace it, and there will be an 8-hour shutdown for power when we go to replace the power. All of those things are still being engineered, so I can't tell you whether or not that's for sure, but it's pretty typical. So sometimes PSC comes back to us and says, hey, the transformer is just fine, we don't have to shut down anybody else's services, we're only going to affect you. And they only take down my power pole, and we're up and running. We are actively under engineering for that right now, but I can't tell you whether or not PSC has approved that or not. But at the worst case scenario, power would be shut down for a maximum of 8 hours if we had to replace a transformer. The same thing is true with City of Bellevue and the water meter. They have an 8-hour window that they can notice. They do give notice 48 hours in advance. That the water would be shut down for whoever's affected by the shutdown. In my experience, it's almost always less than 8 hours. It's probably closer to 4 when that happens. We do everything that we can to facilitate the work as quickly as possible, get the service back online, and get people back into service as quickly as possible. Phone, cable, those kinds of things, all the dry utilities, there's no shutdown. So that would be the two facilities that potentially could get shut down during the course of our project.
Is there a notice protocol in place for shutdown of utilities or telecommunications?
There is. Both the public utilities do their own noticing.
Okay.
It's not required by the builder. They do it themselves.
Okay.
So PSC will go down, they will knock, they go door to door and knock, and they provide notices, and then the same thing with City of Bellevue. They also do the same thing. It's not just something that goes to the mailbox. It is actually a physical door knock, notice type of thing.
Yeah, I had a question about I guess, kind of in continuation with Sean's question regarding the trees. I was wondering if just like more information regarding how it fits in with the tree code and how it's permitted could be, like how is that's a good number of trees. I'm just looking at the map. A bunch of them are on the property line. I wonder if is that necessary to remove during the time of excavation, or can they remain in place and then be removed after a period of excavation? And my question was also regarding like the tree code and how the permits fit in place with if there were waivers involved or anything like that.
Okay, so there are no waivers. The project is considered under development. They have performance standards. So even though they are removing a large number of trees, the trees remaining on site still comply with the tree code requirements. Part of their tree removal, you can see there are 2 right-of-way trees that are being removed along Evergreen Point Road, and those have to be replaced with trees appropriate for location in the right-of-way under a power line. As far as removal schedule.
Yeah, removal schedule and potentially the reason why the trees are going. It's a very small, tight lane. The driveway has seen a lot of significant heaving from roots and things, and then there has been actually multiple trees that have failed and actually hit the prior home. So there's a concern for that. There's also a concern for daylight and some things. We've carefully analyzed the site. We've worked within the tree code of the current city tree code policy, and those trees would come down fairly early in the process because of the falling technique. We would come in immediately, remove the home, create a flat space. Those trees would be fallen into the property before we do any excavation and removed. So they're not providing any screening to the neighbor to the south because they're all limbed up. So so those trees would come down, the screening fences would go back in place on the lane, and we would proceed with the excavation.
Jason, those trees, aren't those Leland cypresses, a good chunk of them, good number of them?
Yes, there's a big chunk of them. I do have a big
And the reason
packet
I know
of
that is
pictures
because when the trees fell, we were actually out there, and they had talked about back then, before this project even came up, and Leland cypresses are a tree that are actually exempt from our tree code
Yeah.
because of their destructive nature.
Well, they were planted originally what I believe to be as a hedge,
Yeah.
and they got unruly and very big.
Okay.
And in the process, they've become kind of unsafe in the fact that we've had multiples of them fall. And so, so the idea is to open it up a little bit, preserve the lane, and meet the city's tree code.
Can you give me a sense of the local topography with regards to the trees and the adjacent properties to the north and the south?
Topography-wise.
And like what their tree situation is like?
So topography-wise, as in the sense of trees, can you bring up an aerial?
Yeah.
Yeah, that'd be great.
Yeah, thank you.
So I'll just, does Google Maps work for everyone? Is this okay?
Yeah, that's fine.
Maybe Google Maps is not the best one. It's a little weird. There we go. Okay. Fantastic.
So our property is right here,
Yeah.
and,
Oh, it's working again.
our property is right here. It's surrounded by trees. This is a lane of a corridor of trees that come all the way up. Mature tall trees end about here. The rest of these are fairly short in nature. This is all a sculptured lawn with
Yes.
some ornamentation, and so the trees that are slated for removal are the lower half of the trees that you see here.
So it's a double layer of trees.
It is. It's
Okay.
lining both sides of the about 11-foot wide driveway. Anything else for me?
I wanted to clarify the record that Barbara Cole is on the mailing list per Exhibit 4C. Previously, we had speculated whether she was on the list, and she is. Barbara Cole being the
letter.
Oh, she is.
Is there a number on that exhibit?
Exhibit 10.
Exhibit 10, so she's exhibit 10.
Or her letters.
Her letter is exhibit 10, yes, that's.
And I just want, I'm kind of following up on that. Has there been any objection from the neighbor that's most affected in the lane, the private lane? What is their feeling about the project?
No, there's definitely been discussion between the neighbors of the tree removal. They are aware of it, and there hasn't been any negativity towards our plan.
Any more questions? Jeannie? Randy? I'm good? Jean? Laurel? Sorry, Laurel? Okay. I think we've talked enough for that part. We need to go to
The public hearing.
public. Any public notice or public
I
forums?
have no speaker cards for this.
Do you live in the house next, you guys? Are you in the house next door or the house right there?
I live in the, not the house next door, the house, the third house in the lane.
Okay. Just you're here, and we don't always get somebody. I mean, a lot of times it's just us. Is there any concerns you have or any questions you have? The best part about what we do here in Medina is, this is your chance to talk to the builder. This is your chance to say, hey, we had one person, they asked if we could move a dumpster just because they didn't want it close. Come to find out it was right in front of their bedroom window and kitchen windows. Is there some question you have? That's something that you've seen, or just a question? What the heck?
You understand I'm building as well.
That's fine. Do you have a question about this? No, it's fine if you're right there.
Putting her on the spot.
Yeah.
Do you have any questions about your own project?
No, it really is a benefit to the community that it's not explored or, it's not used enough, but, it gives the public the only chance they have to talk to the builder and talk to the city about a project. Okay, thank you. Thank you for your time tonight. Yes, sir. Can you come up and state your name?
Yeah, actually, can you come up here so we can get this on the recording, because we can't.
I
pick that
know,
up.
but please, just come up and say your name, and it's okay. Please. Yes, please. So that more people know it's okay to do this. We're not gonna bite.
Yeah, we have to do it under testimony. Raise your right hand.
Yeah,
Swear to tell the truth.
I'm telling the truth, yes. Yeah, my name is Yuri, I'm just building in the area as well. I have a question, what's the structural coverage for this project, including garages and business?
Thank you.
So Jason brought a copy of the building permit plan set, and this indicates a total structural coverage of 20.81%, which complies with the 21.0% requirement in the code. That is 4,175 square feet.
That's the footprint.
And this is,
Footprint, yeah, structural coverage.
and this is R
20.
20? Thank you. Okay, so we'll close the public comments. Okay, for us, go ahead.
You want to?
Well, we went through, no, I'm good, go ahead.
Okay, so I move to approve the staff recommendation. Part 7, it's indicated on Part 7, page 12, with one addition. I would add condition P relating to the SaniCam.
Camouflage.
That the SaniCam.
Speak up so they can understand. Randy Reeves is the one talking about the
I
SaniCam.
couldn't wait for this.
In case, when you're listening
my
to this
big moment.
recording.
That the SaniCam be appropriately camouflaged to be obscured for the neighbors' views in a reasonable way.
So just to clarify, the motion is to approve the construction mitigation plan subject to the conditions in the staff report with one additional condition, which is to add camouflage to the SaniCam.
Thank you.
And we believe it'll be condition P, just to help.
Right, condition P, 3P. So that's a motion, just need to know if there's a
Do we have a
second.
second?
A second.
Okay, so we have a motion and a second. We have, the motion is to approve this construction mitigation plan. We have one condition, the SaniCam camouflage. Is there any other discussion? Does anybody want to discuss the camouflage? Do you have, yes?
I was hoping we could, just from staff, get more information regarding, I am worried about the traffic and all of these projects occurring at the state. Is there any protocol
We don't
for?
have, this project, each project is individual, and we don't have an aggregate.
Yeah.
I mean, well, there's a rule, is there? There's nothing in the city code
Project
Okay.
specific.
that gives us I know what you're asking for, but we don't have an aggregate, okay, there's only, 100 trucks a day, and once that's utilized,
understand.
we can't have 101.
What I can say for the record is that, we've done traffic counts. We have a level service of D adopted for our intersections, which is where we adopt our level of services. And these trucks being added onto there don't even come anywhere close to us. Because even at its busiest time, which is at the peak periods of the day, the intersection at 5 Points, for example, operates no worse than a C. And so, and that's not just the school, that's anybody else coming through there and stuff too. So the additional traffic on there doesn't actually even come anywhere close to moving us below the D, which is the adopted
What week is
standard.
Medina Days? August, the third week in August?
What's that?
What week is Medina Days?
First week of August, I think.
Can you have less trucks in the first week of August? Just volunteering, that's it.
Yeah, I mean, we can bring a little bit more analysis on traffic as a general topic, not necessarily on a construction mitigation. But if you guys want to have a general discussion in one of your meetings, we can certainly talk about traffic.
And maybe we can bring it to city council to ask, they have to direct us.
Just in general,
Right,
since we're
it's
talking
where we can
about
have an aggregate number of trucks or an aggregate,
Okay.
because I believe that, you brought up the concern in the last council meeting and tonight, so I think you have a question about how to control some of this.
Yeah.
Yeah, and like I said, what I can do is I can see if we can find some folks that can actually talk to you guys, give you just education about traffic in general and how the counts work and how all that stuff
So we have a
fits
motion
together.
and a second?
Anyway, just to answer what Ted was saying, that's one of our out of scope issues, so not to say no, but it's not part of our issue. But we have a motion, a second, and a condition met. Do I have any other discussion? Okay, then I'd like to take a vote. All four?
Aye.
Opposed? No opposed. Build your house.
Thank you. Someone want to go get Mark?
I'll get him.
Okay.
Leave him out there.
So Sean, I would actually recommend for the next topic that maybe we can hold off on the communication, since the main thing I just want to know for you is that May 21st, the council's suggesting a joint meeting, and we would have time in April to talk about the communication stuff. So if you want, we can postpone the communication and just actually jump in, because we do have a open house coming up, although you'll have your next meeting before that open house, but it's only a week before it, so on the school height and the rezone. So that's what I would recommend, is just postpone the next item, and then we can just jump into the last item.
Thank you, Christina.
So
Thank you,
postpone
Christina.
H1 is your recommendation?
I would recommend we can do the communication thing at the next meeting.
Okay, that should get us out of here by.
Yeah, I'm trying to be conscientious about the time of the clock.
Yes. So we're on to H2. Continued discussion on area-wide map amendment with school text amendments.
So we've already talked about the map amendments.
Let's wait for Mark.
Okay.
Thank you. Fun to tease him, but we should give
Yeah,
him his due.
well, and just, Mark actually has talked to me about this a little bit too, so he's also aware of what we have here. Welcome back, Mark.
Well, it didn't pass, Mark, sorry.
Better luck next time.
There are a lot of issues.
Yeah, 1, 2, 3, 4, 5.
So we're going to just jump into the school height stuff, and we'll table the communications to the next meeting in April.
Discussion, or do you want to tell us about what's next?
Yeah, so, well, I can go real quick over what happened from after the last meeting. You guys gave me some feedback and some direction, and so I went back and made changes. I'm going to skip over the map because I don't think there's really any more discussion on the map part. I think you guys already did that pretty well. So if you go and jump to page 3, we'll just jump right into this. You'll see in red, I rewrote those conditions about we have the additional 15 feet in height. That was something you guys agreed at the last meeting that you wanted to have put for the open house. I reworked, based on your input, the criteria for that height.
I got one a little bit before that. After reading it and kind of studying it and everything, 20.32.030 would be BB. Where the school is located on multiple lots, the director may waive setbacks located interior. I don't think we need that.
Yeah, you do, actually.
No, because there's only one with multiple lots, then it is a variance. I mean, that's the definition of this. That means there's only one school doing this, and it's not their property.
So have your discussion with the rest of your planning commission members, but I will say that they would need a variance without this.
I'm not trying to create, I'm just saying that
Just so you're aware.
That makes it a variance. I mean, this line makes it a variance.
No, this makes it actually an outright allowance for it. And again, you don't have to put it in there if you don't want, but if you don't, then they will need a variance based on their design of their project that they're requesting.
How do we do better wording so that it's not, because the other two don't have multiple lots.
No,
Unless they were
I understand that.
purchased. So if we're writing it for one school or one property, it is just a text variance. It's not even I understand it's still an amendment.
No,
but-
because
My
the,
interpretation, if I may.
Yes.
Is it allows in the future, say, 20 years from now, somehow there's a divisible line that occurs on some other school property, it would actually apply to them as well.
if they purchase additional lots.
Yeah,
So,
so it would, in that respect, it is a code amendment, because it would, this rule, as written, would also apply to that future scenario.
Then, I guess the only other side is the setbacks then. I mean, if we're, I wanted to build a building, but my biggest heartburn is this is a text variance, the way it's becoming, and so the setbacks, can you grandfather in the schools?
so again, if you want to have the conversation, this is what you want to have with your fellow planning commission members, because it's a policy question. And the policy question you're asking, if I understand you correctly, is whether you want to allow for a waiver of those interior setbacks. And that's really what the policy question is. And that's a question to have with your fellow planning commission members.
And that's what I'm saying is if we're going to give the multiple properties so that, and I guess leasing counts, it's not purchased, it's not theirs, because the school could move and then we have or end the lease, and then you have a building that's not part of the school. It's not the same as if they're building it on their own property. I'm having a lot of trouble with the lease. If they were purchasing it, it changed it. I understand we're moving the line so that it's public. Okay, we're zoning it, I got that. And that's good. We could zone the whole city public, it really doesn't matter.
That's a private contract though, and this is,
Well, if you're, but it's not,
still
it's
allows
not,
for private
it's not,
contracts to be entered into.
well, just like the CMP we just went through, you have to prove you own it before you can build. That's a huge part of the CMP. You can't build if it's not yours. So this is one where they're building on leased land, and the golf course should probably be the one asking for this. It's their land, and then they're going to lease it to the school.
So
That's my point.
The leasing doesn't take place at this point. The lease is relevant when they come in for permits. It's not relevant at the legislative level.
So they're not multiple lots right now.
They would be at the moment, the school's not on multiple lots. That's not what this is about.
Sean, if I may make a suggestion.
Sure, discuss, please help me.
Would it be wise for us to go through the red changes? So we have the totality of the document as it's changed, and then we can come back and discuss any components of those changes and any other provisions. Because I think that may be more efficient than focusing on this point.
Well,
so we can come back to that.
Yes, we can do that. We can go through and then discuss all the objections at the end. That's
okay.
Robert, please.
Okay. So I'm going to, as I was mentioning earlier, at the last meeting, there was a consensus about the 15 feet additional height, but what you wanted me to do was come back and take a look at the criteria that would potentially allow for that. So what you see, what I ended up doing here is I ended up reworking the whole thing based on the input you guys gave me. What you see in red is basically new type of stuff. What's in black, even though the wording may be different a little bit, it's still the same basic concept that we'd had from the previous one that we had discussed. So starting with there was a lot of, what I ended up doing is I went back, and Seattle in their code actually was very specific about what the things could be above height. And kind of what I got the sense from the Planning Commission at the last meeting was that there was kind of a desire to try to make sure we could limit this down a little bit. So what you see here is basically what can go above the height would be open railings, planters, play equipment, stair and elevator penthouses, and I added a definition for that so there's a little bit clearer understanding on it. And then open mesh fencing for an outdoor play area, and of course we do define outdoor play area. So that's actually narrowing down. If I think at the last draft we just said outdoor play area, which was a much more broader this actually starts to narrow down more specifically what actually can be used, or what can actually be the structures and stuff, and then what they have to be associated with. So it does narrow down what could be over the 35 feet in height. Then this was in the previous one, but we also had talked about 15 feet was not going to be an automatic given, that they have to demonstrate that. They will demonstrate that with a special use permit, whatever their height is over 35 feet, whether it's 1 foot or whether it's the full 15 feet, they would have to demonstrate that as part of the special use permit process. We also talked about at the last meeting, the outdoor play area is uncovered, and you'll notice I pulled out the whole thing about the access, because that's the next one, that's the new language on the next one. The total footprint of stairs and elevator penthouses above the 35-foot maximum height is the minimum necessary, which is something you guys wanted us to put in here, but then we put a cap on it, just like we talked about the height. We put a cap on how much of a penthouse, a building, solid structure could actually be above the 35 feet in height. So that was what D is. Under E, we had talked about putting a limit based on the building, and then there was also, it was brought up about also maybe using lot size in there. So 35% is what you had voted on at the last meeting as the total, when based on the total footprint of all of the buildings that make up of the school. 35% was the standard that you guys had voted on to use, that the play area and the penthouse could be. And then in looking at those numbers, I took a look at the lot sizes and looked at a number that was somewhat pretty close, and so that's where the 10% came from. 10% actually, because structural coverage, I think it's 30%. I can't remember what the structural coverage is, but roughly that 10% is like about a third of what structural coverage could be on the property. On the next page, F, all structures above the 35-foot maximum height must be set back a minimum of 3 feet from the edge of the building. This was a conversation also. I think, Mark, you brought that up at the last meeting, and I'd asked you to kind of have some patience and let's just look at what it would look like with one, trying to keep it simple. So anything above 35 feet does have this requirement of being 3 feet. Seattle has a similar requirement. So since we looked at the Seattle code for some of our inspiration on this, it does follow some of what they do there. The next one, this is really an important one. This is the setbacks. And you'll see I actually changed the approach on this. I think before we had like more like what was set for the building. This actually decided to look at the property line specifically. And what I ended up doing, so you guys could kind of get an idea what it looked like, there are aerials of each of the schools and what the setbacks would be applied and what those would look like if you use the 150 foot. So if you go to the aerial photos in here, you'll see in green, well first you'll see in black basically the setback lines from the property. The property lines are in red, and then the black is actually what the distance would be, and I gave you the numbers. And so then the green is basically showing you the area that could potentially have this above 35-foot height additional outdoor play area. And you'll see on this, you'll see that it's a portion of the St. Thomas, and then it goes into the golf course. And I wasn't going to color the whole thing because the golf course is huge. It's 133 acres, I think. When you look at Bellevue Christian, you'll see that it gets pretty narrow. It's a long, narrow strip for a lot of it. And in fact, even though it would be a 55 from that east property line, in practical, the way this thing ends up angling down, it's actually 170 feet is actually the closest, and it's actually only a smidgen of what you could really actually have there. Probably not very practical. And then Medina Elementary, which has 3 property lines, you can see that it's a very narrow strip there of 150 feet around the 3 property lines, and then there's a 55. So again, the 150 is for discussion purposes. If you want to look at different numbers, you're more than welcome to. We talked about this before. And also, again, keep in mind that this draft you're looking at is also for the open house, is what we're looking to create right now for what we want public feedback on. You're not locked into anything here until you actually take your vote. I'll keep reminding you of this because you can change your mind on things all the way up until hearing and vote on it. So just always keep that in mind. So back to page 4, H, we had talked about the time, and 8 to 6 p.m. daily, 8 a.m. to 6 p.m. daily was what the Planning Commission had voted that they thought was the best approach on it. I came up in the last meeting with this discussion about amenities, about a public amenity. And so you'll see that added in here, and then there's a little bit more language around it under G, which is on page 6, where we talk about where public amenities require the property owner must provide resources and convenience facilities and or other benefits that can continuously be offered to the general public for their use and or enjoyment with or without charge. And then I gave some examples and stuff in here. That language probably can still be massaged a little bit more. In fact, I haven't had a chance to really work with the attorney yet on it because we'll want to massage it a little bit more, but this was just to start giving you kind of an idea. And this could be a variety of things. I mean, ultimately what we'll do is we'll look to the applicant through the special use permit process to propose a public amenity that meets this requirement, and then we would evaluate whether it's appropriate or whether it's sufficient in meeting that requirement. And then, of course, the hearing examiner ultimately would then make a decision on it. But the public would have a chance to comment and provide input on it as well. And then, so going back then to page 4, the last thing on there, J, because there was discussion about wanting information on referencing like noise and light and stuff. So you see language actually pulled from the special use permit criteria that we pulled in there that shall have no material detrimental effects on the neighborhood properties due to excess noise, lighting, or off-site traffic generation. Now, one thing that was brought up at the last meeting, there was questions about noise and kids, and I think really the main question on the table on that is what's the difference, would there be a difference between the noise at the current playfield, ground level, versus then if you had the kids up on the higher level. St. Thomas just kind of got some of their stuff completed, and I don't have the study yet, but they'll be getting that to us, and then we'll have our consultant. So we'll have more information for you at the next meeting to try to take a look at that comparison. We're not able to do it tonight, but again, like I said, that's why I said you don't necessarily are deciding on the final product. You'll still have a chance to continue to refine it. But at the April meeting, we should be able to talk to you a little bit more about what difference it looks like the noise impacts might be from currently where it's at the ground versus then if you all of a sudden allowed, a playground at the upper and kids are up there playing, how that might look different noise-wise on properties in the area. So I don't have it for you tonight, but we will have that for you at the next meeting. Because I think you plan to send that to me. I'm not sure when. Do you guys have a time when you're going to send me the noise information?
They were out yesterday doing their field work, and we would expect we will have this within the next couple of weeks.
Okay. Note that April 18th, right? Is that the Wednesday? Yeah, and I need time for our consultant to also then take a look at it too, because I want to get your information, and I want our consultant to also be able to give you information on it and take a look and provide you feedback on it as well. So that was very quick through, a quick summary of stuff. I can go over things again if I was too quick on it, or just however you want to go forward with questions and stuff.
Go ahead, Mark.
I feel pretty good about the changes that were made. I think we're ready to have it be available for the public to review and provide additional input at the open house. So I'm feeling really good about this latest revision.
Mark, I have a question for all of us, and that since you're talking, it could relate. You may have a specific comment regarding the 150-foot setback. And Robert, chime in on this. Where did that number come from? And what consequence would there be if that was reduced to 100, for example? So Bellevue Christian could have a little bit more flexibility. So
yeah, I think, speaking for myself, I know that the number 200 was thought about, 100 was thought about, and for this document, we said, let's just kind of go for something in the middle. And saying that, I don't know that I have any objections to 100. In some respects, like you were saying, that to these other schools, it might be a little bit more of a benefit. But I might add to that if we reduce that number, I think the public benefit component, to me, is more of a need. And I could see having the public component, public benefit component, be reduced if you're, say, 300 feet in or 250 or whatever. But if you're closer to the street, then maybe, there's more of a need for that public component. So I could see it be tied to that. But I don't have a strong feeling one way or another. I'm just kind of throwing that out as a possibility.
Yeah, and I would note the 150, because at the last meeting, I kind of, it's not unanimous, I think, in support of this proposal. I think we've just become pretty clear. And I'm not sure whether what the support of the community is, we don't know yet, because we haven't really gotten any feedback from the community yet on it. So the 150 was proposed here as kind of a compromise, as Mark mentioned, kind of a middle ground. But you can look at something less, something more. What I would also note, though, is what's interesting about it is like Bellevue Christian in its background has a freeway. The place where you probably potentially, if they were going to, honestly, I don't think the odds are great, but again, we have to go like the odds are that the other schools may do this. Medina Elementary is probably the one you've got the most closest with impact on all directions of properties, although on the south side, most of those properties have, I think, 100-foot tall hedges screening them from the school and stuff. But the 150 was basically kind of a compromise for something. But again, if you want to look at a different number, whether it's more or less, that's all part of your conversation.
So in the case of Medina,
Yep.
in the case of Medina Elementary, like the 55-foot is on the western edge. Perhaps in terms of how we define what the rear property line is, because I look at this and I see where the entrance to the school is, and I think the southern side is the rear property line.
Right. And just so you know, when I first put this together, 75 is what stuck into my head, but the way our codes read is basically your front is going to be a public street. It always, we're talking about when properties that are on a public street, that is always the front, and then everything else orients off of it. In the case of Medina Elementary, you have three fronts. When that happens, what ends up occurring is that west property line, north, south, east, west, west property line, the 55 one, what that ends up being is it's a rear, because if it runs parallel to a front, then it's a rear. And so that is a rear to the east property line, but it is a side to the north and south property lines. When that happens, the property owner gets to opt whether to apply a rear or a side. And that's why I put it down as a side.
Okay.
And Mr. Chair, we know we've sort of done an ad hoc process today, but we did want to note that Mr. Palmer had some comments, if we would have an opportunity to speak to those briefly.
I just have one more question, and we'll do that. There has to be a back or a rear to St. Thomas, and it's not the whole golf course.
Well, they do have a rear property line. But what happens with that, going back to your earlier question, that can be waived. And actually, even St. Thomas has a rear or a side. It's the same thing, but they opted, I believe, way back when the work was being done, they opted to call that a rear on that north property line, so it's considered a rear. But that's, again, why you have that waiver in there of 30 feet.
The way this is drawn, you've already waived it.
That takes into account the provision that has a waiver. The way it's drafted currently about waiving it so that they're not into a variance. And again, if you want to put them into a variance, then you can put
I'm not trying to put
setbacks
them
in there.
I would like you to put that in there and then note that it's being waived.
It is shown in there. That's why you see that drawing, the coloring in the way it's colored in. It's colored in that whole space there, shows you, and you see a property line down the middle of it. So it is indicated.
No, I respectfully disagree. There's not a 55-foot rear on the school, and then showing that that's what's being waived.
Because that's not what's being waived. What's being waived is the designation of the property line, the requirements for setbacks at all from those interior property lines.
That's what I'm asking to be delineated.
So again, and I'm not going to have an argument about it. You can have your discussion how you want to go about it. We're going to put some other stuff together for the opening house, but this is what I presented to you for tonight. And I think there's enough for your discussion, But if you don't feel, then that's, again, have it with your fellow planning commission members about it.
Okay, speak please.
Chairman Schubring and commissioners.
Is this the same as the one
It
that
is.
was,
Yeah.
the previous one that you?
No, it's not. It's different.
Been revised, okay.
It's different.
Okay, that's
Oh,
what it
thank you.
provides.
Okay, thanks.
First of all, thank you for the opportunity to make a few very brief comments to you tonight. I recognize the lateness of the hour and very much appreciate the opportunity to speak. First of all, we're generally very supportive of the direction of the code amendments language is taking. And based on the discussion last time we went back, we heard what you said and we tweaked our plans to reduce the potential impact. As an example, this is now set back, the safety netting is set back 3 feet rather than the 2 feet it was previously. We also have set back the elevator and stair housing to 3 feet rather than right up against the edge as it was previously. We'd also reduced the size of the elevator housing and the massing as we'll get to that in a second. We do hear this and we want to make sure that we are good neighbors for the community. Looking at the kind of a revised wall section, as you can see, again, this is from a planning document, but the stair overrun section of this would be at the minimum of 42 feet. The elevator is what's tall. The elevator overrun is, the housing is 46.4. That's the highest thing here. And then we did some research and we said, it turns out that 14 feet is considered the optimal height for the fencing. It's not just keeping kids in; it's also keeping balls in and stuff like that. So that was where the research came back on that. So we are committed to reducing the massing and the impact on the neighborhood. Looking at it from a different perspective, kind of a three-dimensional perspective, would kind of show you this kind of layered cave effect. If it's also possible, again, it's all subject to design and the engineering, but if we can do some sort of pitched roof near the edge, again, to try and reduce the kind of mashing and the visibility to the community, we're willing to do that as well. Although I must note that this section here is interior to the property. It would only really be seen by the school itself or the golf course's maintenance building, which is adjacent to it. It's the interior corner of that. So we're trying to respond to that, and we think that we can support pretty much everything that's in the proposed code amendments. I did want to address the topic of the community amenity and the necessity for that, though, and I wanted to kind of just point out that the school, by its nature, and it's not just us, it's also all the other schools in the neighborhood as well. By their nature, they are providing a community amenity, and as distinct from another type of property user. So, as an example, and again, other schools could say the same thing, but we've literally educated thousands of local kids, and over 1,000 of local kids attend our summer camps. Most of those are not St. Thomas students. We make our facilities available for that in the summer. In the February of each year, over 1,200 local families come and look at summer camp operators. We're doing this as a community service. We also have local community groups, from the bagpipers to the Cub Scouts, to the Girl Scouts, to local dads want to have a pickup basketball game. We make our facilities available. We think we're doing this because we want to be good neighbors. We're not sure that from a safety and security standpoint, it makes sense to mandate that we do this on a continual basis, because we've got to be able to control who's in the building, and we're very careful about, again, safety and security issues. So anyway, that's the comments that we wanted to make on it. Other than the kind of the additional public amenity topic, I think everything else that's in the proposed code amendments is we can certainly live with. We think we're developing up as good law. Thank you.
Mark?
Is there anything within the ordinance as it's proposed right now, the language of the public benefit amenity, that you would consider acceptable if it were changed? Is there some language that could be added, taken out, that makes it more comfortable for you, and then at the same time we would have to see, does that make it, is that, we want to treat all the schools fairly, so it has to be something that's equal. And my idea of, I think where it really gets important is where it begins to impact the public more, that amenity is important. Where it's located as far back as you are, I think it's not quite as critical, but again, to be fair with all the school properties, I'm trying to, kind of find a balance there that, if the community is going to allow schools to do something extra beyond what the standard code is there something that and I think what you're doing sounds great to me, but I don't know if when you're looking at the special use permit, that would be acceptable, and would we have to put some criteria on to say these kind of things are acceptable, like he mentioned, or I just don't want somebody to come by and say, oh, well, that's not enough, you have to do more, so therefore we're not going to
like I mentioned too, I think the language needs a little bit more clarifying, but what I would note on the public amenity is that for it actually to really be something that we can even enforce and stuff, it probably needs to be something that's physical. So here I gave the example of a civic space, but it may be some other improvements and stuff. And so this needs work, the language needs work on it, I think what you're talking about trying to narrow it down, if the Planning Commission wants to have a requirement for a public amenity in exchange for the additional height, you have the right to make that as part of your recommendation. We do need to clean this up and make it a little bit more specific so it's a little bit more clarity to it. Like I said, this was just to get things started. This wasn't actually as easy to find language on as I thought it was going to be, because a lot of things are very more like open space bonuses, or they get into civic centers or things like that aren't really pertinent to this situation. So it's going to take a little bit more time and some refinement, but the language does need to be more precise. I don't disagree with that at all.
Yeah. And I respect that, and I think that I'm a little concerned about, I was the one that brought it up, and I'm kind of wondering, is that something that, I don't want it abused, basically, but at the same time, it's probably easier, like for a high-rise building downtown Bellevue, to provide a public space or a bus stop or a bench for the citizens to sit at and relax to get an extra story or whatever it might be than it is in this particular situation. So I guess sympathetic to the difficulty.
Commissioner Nelson, I would also say that, in my mind, something like a TIF or something like that for commercial development or residential development, I think the nature of the property user is different than that of a school, because everything we do is about providing a public benefit. And so I see a difference in that sense. It clearly, these things could be some sort of impact on the neighborhood. I get that, but I think that there's also a difference in just the way that I would view the whole issue of impact.
And I think, just for the record, Ian Morrison on behalf of the School of McCullough Hill, I think, Commissioner Nelson, what you're speaking to is there's a challenge, and I think Robert was moving in that direction, is for conditions of requiring something for any property owner to provide some sort of benefit as a condition of doing the development, there needs to be a nexus and a rough proportionality between the benefit that's being provided through the legislation and the impacts that are happening because of it's getting right to that nexus. What's the nexus between a new rooftop feature and requiring some sort of mitigation of those impacts? And I guess what you're hearing from Mr. Palmer in the school is we're still sort of struggling of what is that nexus? Is in creating a rooftop on its own property that's keeping kids in its own school, what is the nexus that requires some type of mitigation? And I think that's a fair question to ask, but it's a hard question because I think from the school's perspective, they haven't quite seen that nexus yet.
Well, and I would put on the record that the nexus is the request for additional height. That's your nexus, is the request for additional height that otherwise isn't there.
Yeah, and I think then that goes to the rough proportionality of whatever is being required needs to be mitigating that request for height, and also needs to be roughly proportional. So I think it's something that is a conversation to keep going, but those are sort of the framework that, as Mr. Epley can speak to, is always the requirement, sort of the legal requirement when you're talking about conditioning new incentives.
Do you, to your knowledge, does Medina Elementary, or let's say the Bellevue School District, do they have a requirement to offer their fields for, for public use, for soccer, et cetera? Or is there a requirement to offer those for rent, for flag football, et cetera? It's more of a curiosity.
So I know that they have, this Bellevue School District has a policy that allows for potential use of public facilities, but I don't know off the top of my head, and we can confirm whether there's a mandate to provide that.
Thank you.
Yeah.
Well, just a suggestion on your public amenity. I mean, you got to start somewhere. So each foot of height give could be a certain number of days of public amenity. I know you're already doing part of it. I mean, it works out pretty quick, 26 days per foot. I mean, right there's the whole year. Obviously, that's probably a little much, but you got to start somewhere.
I don't quite.
The give is the feet of how tall you can make it. So an amenity, everyone says, how do you quantify it? How do you quantify it? So I just quantified it. 26 days per year per foot. You want 14 feet, 26 days to be, it's the whole year. Obviously, it's an argument of arguments. I got that. But starting somewhere. In other words, what would be a meet in the middle give? In other words, I know you're doing the deal with Cub Scouts. I know you're doing other stuff, but we're looking for a way to legislate it and actually put it in here. You're saying security, okay, but it needs to be quantified if there's a give. In other words, if we're going to take, so the give that we're giving and the take that we're asking for, there needs to be some kind of a quantification. So maybe we can work towards that end. I'm making a suggestion for a process.
Right, and as I mentioned before, the language there still needs working, and it's also going to be something that the city could actually even enforce. And for example, using their facilities isn't something we're going to be able to ever enforce. So we would have to look at something else as the things that we would identify. And as Ian mentioned, yes, there is these requirements about nexus and proportionality, but I would also note that this is actually not being given as a given right. It's more of a bonus, and language needs to be written that this is a bonus height and stuff to strengthen then we can take a look at stuff like that. So again, but this language isn't final. This is just was a start, and really the question for you guys is whether you want us to keep pursuing the public amenity in there, and then I'll actually need to work with him, and we'll actually have to refine it more, because like I said, this was just something as a placeholder for tonight.
Gene.
Yeah, I have a question on page 4. It may be wordsmithing, maybe but under H, the use of the outdoor play area facilities, plural, does that mean all outdoor play areas then for each school?
So we have a definition, and I think that came up before. That's why I was trying to remember what the thing that came up before on it. I'm trying to think. I mean, we can get a little bit more precise on it.
Well, that's the reason I'm concerned about that. It's pretty open-ended because the other two schools have a lot of play area that's outside, it's not elevated. If you're really talking about the elevated area, or that new area,
right,
then I think we need to be more specific. Otherwise, and I'm not sure how you're going to enforce a 6 to 8 o'clock for all of the schools, because the daylight saving in the middle of summer, kids run down to
Well, we wouldn't enforce, this is actually only applicable because it's a criteria of the additional height, so it only actually would apply if you're doing the additional height, but part of the question that you are asking, which is a good one, is they do the additional height, does it apply both to the rooftop and does it apply down to the main play field? If I understand you correctly.
I understand it's because of the height, but the way this sounds to me at least is that this is open-ended for all play areas for all schools.
No, it only applies
But
to the height.
It doesn't say that.
Well, it does because you start out with the criteria at the very beginning of 2, and it's, except the height may be increased by up to 15 additional feet provided, and then these criteria apply to the 15-foot height bonus. They're not something that applies universally to the rest of the schools.
So the plural doesn't make any difference then?
No, it's an application to the, additional height.
As one facility. I'm
Right.
sorry to be picky.
No, it's
wordsmithing,
good.
But
No,
people are going to read this, and I'm looking at this, and I'm seeing a whole different picture.
Right, and again, like I said, so you have to read it in whole, not in isolation. And so when you read it with the whole, but to that point, the way it reads right now, St. Thomas would have the restriction, it could be interpreted to say St. Thomas has the restriction if they go for the additional height.
Yeah.
If they don't, this doesn't apply. But if they go for the additional height, the way it's written right now, you could say it applies both to the rooftop and to the ground, playgrounds, the way it's written right now. You could interpret it saying that.
Well, then my next question, and this schematic, I'm not very good at spatial design. If you're going to limit, this is the rooftop. This is the limitation is for the rooftop. This 8 o'clock to 6, right?
Right.
Okay.
Well, that's a question, because I intended it that way, but I guess it's a question for you guys to talk about. If we did the limitation of 8 to 6 with the bonus height, would it just be for the rooftop, or would you want it for the school rooftop and the grounds?
See, this is my concern, because I think it's muddy. And the other question, if it is restricted to the rooftop, I can't tell because I don't understand the schematics. You can use the gym after 8 o'clock, but you can't use the rooftop. Is this what I'm understanding?
That's the way I would.
Then how?
Right, that is correct.
That's what I understand. Then how do you block anybody? I mean, I don't understand how to get to the stair or the elevator versus a gym. So how do you keep the kids from going up there?
I think you probably put a sign on the door that says it's, closed at 6 o'clock or whatever it is.
The same way you say a park's closed and the people that abide by the rules, obey by the rules,
Yeah,
and
but you got a bunch
people
of
that don't
kids you're
are
talking
subject
about.
to.
The other way to do it is, we're not planning to put any, real lighting up there, so.
Well, I was just concerned because, knowing kids, if there's a way to get up there, they'll get up there. Right?
Yeah, I think they probably would, but I think, you have a sign there and you just, there's no lighting up there, there's nothing to do. It's, a great deal of the year it's going to be raining too. So.
Yeah.
Well, and the other
Well, I
part,
just wondered about that because I just could see it, because it's kind of it's a restriction. And you want, if you're going to put it in, how do you can't go down and
Right.
enforce it. Nobody's going to run around at 8.
well, the enforcement would be, as any enforcement is, if there was complaints and we had it, then we would be contacting the school about it.
Okay.
Yeah, I mean, that's how the enforcement happens. Otherwise, they'd self-enforce.
Well, I'll get away from the
So-
play area and listen to other things.
So just for clarity, can you say rooftop, or, I mean, I understand it's implied.
Yeah, no, you're absolutely right. If that's what you guys want to limit it to, this 8 to 6 is only to the rooftop limitation and not the rest of it, then yes, I can add that language to do that.
My recommendation would be to add the word rooftop in between the and the outdoor.
Right.
And I think that makes it clear.
Yeah.
So while we know that I've got a lot of heartburn with the way this, why 8 and 6? I mean, we understand that we're trying to mitigate the noise in the neighborhood. But if we're gonna build a rooftop playground, you're gonna have kids. And like you said, in the summer, we shut it down at 6. What is it, June 22nd, whatever's the longest day of the year? It's light till 10 o'clock. Why are we, do we need to do that? Can we say daylight? I mean, they're not gonna have any lights. The other playgrounds are open what time does the park close? 10?
Dusk.
9?
I think it's dusk.
Dusk?
Yeah, or it may be 10, I'm not sure. One
What
of the
time do
two.
you shut down the rest of the school?
We would certainly support dusk,
I mean,
Dusk is the problem with dusk is it's a little bit too vague.
The 8 a.m. to 6 p.m.
6 p.m.
was,
kind of early, frankly.
well,
well, but
I'm
it
trying
was,
to find a way to.
it's a concurrent time based on a previous presentation, I think Kirk specifically mentioned that time period as concurrent with school programs.
There wouldn't be a lot of use after 6 o'clock, but I could see, again, middle of the summer, or there might be kids running around, we don't currently have any programs that are in the middle of the summer in the evening, but.
Got a rooftop, maybe you could.
Yeah, I think from the point of view of noise mitigation, I mean, I totally agree with having a rationale for all of the limitations that we're putting in, so I like the idea of being consistent with some other, and it seems to me from the idea of a, if we're worried about the noise impact, then maybe we could be consistent with construction hours or something like that.
That was what I was, what is construction hours, Robert?
Till 7, isn't it?
7 to 7, Monday through Friday, 8 to 6 on
8 to 6.
Friday, and Sunday none. And they had asked for it 7 days.
And nothing on the holidays, what do you do about Easter?
And no holidays, and they had asked for 7 days a week on their time.
But we changed it at the last meeting.
I understand, and we can change it in this meeting, we can change it in the next meeting. I'm trying to say, if we're gonna do this, let's make it usable. I mean, so, yeah, you can build your rooftop, but, noon to 1 on odd days when it's not raining.
Well, okay. It also has to be practical to the organization that is operating it, and to schools, and, to any school. They've got staff that are there from a certain period of time, and I think they don't have staff normally at night. They're not gonna run nighttime programs on a roof.
I'm really comfortable with the 8 to 6 because that's what was.
Is there any
That was
problem
what
with
was
8 to 6?
recommended by the head of school.
Yeah, I'd say 8 to 6 would be, certainly satisfactory. 8 to 8 would be, that would be ideal. Just to accommodate, but I can certainly, having had little kids, I can also understand, hey, there's gotta be a limit at some point.
Well, and at the last meeting, 8 to 6 is what you had indicated was fine.
Yeah, that's
Okay,
that's what Kurt.
So if we consider the points discussed, 8 to 6? You okay?
I'm okay with that.
Keep discussing.
I'm in general, in favor of, like, going to the public hearing. I think we're in a spot where it would help all of us to get a public reaction on this, because I think the difference between 6 and 8 is something that maybe other people will have strong opinions on that we haven't, for reasons that we haven't considered yet. So I'm comfortable with 8 to 6. I probably would be comfortable with 8 to 8. But I kind of feel like from the point of view of that, achieving the next iteration on this, that it's a really good time to get public input on it.
I'm really comfortable with bringing it forward. Robert, just kind of a general question about the public amenity section and the rewording of it. Do you have any specific ideas at this time and how you might reword it, or?
Not yet.
Okay.
Like I said, I've actually had some discussion with Ian's about public amenities a little bit, but I need to actually talk with Brian now that he's on board. A little bit more about, because of the nexus and the proportionality and how this works actually as essentially this is not a given height. It's a bonus height essentially, and that does create some different dynamics.
Agreed.
So
I agree with Laurel that I think we're ready to bring it forward.
I think it's too.
And with Mark.
But I will play with that language before we get to the public open house, because the language is kind of,
2J, the use will have no materially detrimental effects on neighborhood properties due to excessive noise, lighting, or off-site traffic generation. What if it does? What's the ramification?
They wouldn't get approved with their special use permit.
After it's built, that's when you're gonna know this happens. What if it happens?
So
it goes back to what I was saying. If you build a playground, they will come.
So as I mentioned, when you go through a special use permit, and you've been through these, Sean, before, you know that there are reports and information that have to be provided that become part of the record, and you use that to establish conditions in the special use permit, and then they're obligated to follow those conditions in the special use permit.
Okay.
And if they don't, then it's a violation of the code, and they have to bring things into compliance, or it's an enforcement action.
do these, just generally speaking, do these conditional use permits, do they have a shelf life?
As long as the building and use exist.
Okay.
Okay, on G, my only suggestion about the setbacks is I would also give them existing buildings. I mean, I see what, you know, if they've got an existing, I'm just suggesting, again, while we're in discussion, since we don't have to have, you know, a rear property line on all three of them, why couldn't they, if there's an existing building, have additional structures there? What would be the big detriment to that? So in your footprints, in your pictures, you've got, you know, here where part of St. Thomas is not in the green, and most of Bellevue Christian's not in the green, and a great deal of Medina is not in the green. Why would be the detriment to saying those setbacks or existing buildings, or existing footprints?
You mean as far as what can go on top?
Yes.
You can do that if you wanted to.
Right, exactly.
I mean, if you do that,
Exactly
then you just establish, basically you just establish, you don't even actually then need this, you would just leave it with the existing language in the code, you don't even need this. So I mean, that's your alternative, is what you're asking about, Sean, is that you just actually eliminate the section entirely. And again, that's a policy question.
What do you think about this? Oh, go ahead. Sure.
Oh,
Sorry.
no.
You're good.
Did you have
Go
something
ahead.
to-
No, I was just.
Oh, okay. I think in general that, because this setback thing is one of the things I was going to bring up as well. And I think that, to my mind, the purpose of having these setbacks is, again, to help mitigate impacts, visibility, and noise. So somehow it seems to me it would be nice to choose this setback figure. It might be possible to tie it when we have additional information from St. Thomas on noise analysis. We might be able to choose a setback that makes sense from a noise impact point of view. And I think my objection to what you just suggested about existing buildings would be that some of the existing buildings are fairly close, much closer to residences, and would have higher impact than if we impose a setback of some sort. So I would be uncomfortable with allowing all existing buildings to add a structure.
Randy?
Yes, those are good insights.
Mark?
Yeah, I'm still trying to understand your
If there was a
issues with the
retrofit, the
setback
existing buildings.
issues. And I think maybe offline you can help me to understand where you're coming from, because I'm not
More if
getting it all
the
right now.
existing schools wanted to retrofit and put playgrounds on top and have more buildings, more
Yeah.
coverage.
No, I'm not in favor of that. I agree with Laurel that I think that we're talking about specifically this, you know, a new structure. I'm comfortable with where we are. The numbers could vary. Maybe it's not 150, maybe it's 125, maybe it's 100. You know, I'm not sure what that magic number is yet, but I do like having a number in there that not only appears as though we're trying to look out for the community and their best interests and to reduce the impacts from noise and the visual impact. What I was talking about, where I'd like to maybe meet with you offline, is your interior setback waiver and the need for a variance and so forth. I'm not at all with you on that, and I'd like to understand exactly where you're coming from. But anyway, in terms of the section we just talked about, I'm okay with it. I think it needs to be in there. I just don't know if we have the right numbers yet. I would like to get the public feedback at the open house and kind of, you know, then look at this again with kind of, you know, fresh eyes and ears and have another stab at it.
I feel like you're inviting me to make another comment. Okay. I think my only remaining comment at this point is I've tried to do some thinking about this question of how how customized is this to St. Thomas? How appropriate is that? What are we trying to, I think, I think maybe some of our setback decisions might go a little bit to that too, because I think there are some things in the current draft that make it pretty difficult, I think, for Bellevue Christian or Medina to, sensibly add this kind of structure if they wanted to, without just reconfiguring their whole property. So but I've done something about that in the interest of fairness and all that stuff. And I don't know if this is helpful or not, but we used to live in an unincorporated area of Texas, and Texas has some funny things where you had to do some legislation at the state level to, it was the only opportunity to create the conditions you wanted to create in localities. And I think they pretty regularly did that, where the state legislature would adopt something that was particular to a metropolitan area with a population in a certain range that happened to be geographically located within a certain distance of the coastline, or that kind of thing. So I'd be interested, I think, in an attorney's perspective on whether or not that's common, and if we were as a city to adopt something. Well, if the direction we're going is it seems to me that this is the best direction to go rather than the variance route, because it's more fair and it creates these opportunities for the other schools, should they want to as well. But I'm interested to know whether, from a legal perspective, this is a, not uncommon thing to do, or if it's a very uncommon thing to do.
Yeah, I can't say I've ever really run across this issue before, but I think if your goal is to establish a code amendment that's going to apply in the future with equal force to all potential applicants, that's sort of the role of the code, and I think that's a laudable goal. Yeah.
So, and Brian, you can correct me on this, because I have come across this before, this kind of stuff before, and in fact, we wrote some stuff before. And I mentioned, we talked about this at the last meeting. The key thing is, however you approach this, whether you narrow it down or whether you expand it, however you approach it, you need to have a public purpose. It has to be more based on a public purpose that's broadly based. Even if it ends up narrowing it down to one property, for example, it is possible to write ordinances that do that, that are defensible, as long as the way you've approached it is from a public purpose perspective. But if you're doing it from a perspective where you're just trying to benefit a single property owner, I think that's where you actually, that's where, at least in the past, where I've understood where you will run into trouble. So when we talked about this before, about these setback requirements, for example, your public purpose you're looking at there is the visual impacts and stuff like that. So as long as you don't try to craft them, so, and I'm going to just say, so St. Thomas gets a 100-foot setback, but all the others get a 200-foot setback. As long as you don't do that, but instead you set a standard that is based on a public purpose, that you can back up with a public purpose, that then is equally applicable to all the properties, you'll be okay. The conditions of the properties may not allow them to take advantage of it, but that's okay. I mean, that's when you get into the specific facts of the permitting and stuff like that, that then becomes an issue. But your main thing, and that's why we've talked about this from the beginning, that why we had to get away from thinking about St. Thomas. St. Thomas is only relevant at this point from the context of, if you don't want them to be required to go get a variance, then you look at how St. Thomas fits into this, but ultimately St. Thomas is the sideshow on it. The main thing is you're thinking about this in perspective of all three schools in the city. Does that make sense?
It does. So it really argues for choosing these setbacks and things like that on the basis of a noise analysis or a
noise,
distance,
visual,
kind of
exactly. And then you can look to what that seems appropriate, and then based on that, how it impacts individual properties is a secondary consideration.
So if it shook out that Medina and Bellevue Christian couldn't meet those criteria, then that's how it
Correct.
shakes out, but
Right.
the goal is.
As long as it ties into a public purpose on why you establish whatever it is that you're doing, and you're not doing it because it's going to benefit a particular property owner. But I mean, I can give you the example, I'll give you the example when well, the golf course is a great example, right? So we made the golf course a permitted use in Medina, because before it was never listed. We made it a permitted use, but we set a criteria that you're not going to see anywhere else in the city. It's 133 acres continuous is required, and some other stuff like that. So, not that it's likely that people are going to be able to buy enough property to build another golf course here anyway, because I think that would be $1 billion, but nevertheless, the criteria is established so that really there's only one place you could have a golf course, and that's where it exists today.
Small change, Robert.
So what I'm hearing is everybody's ready for the public hearing.
I heard something about small change.
Open house.
Oh, the $1 billion just to buy another, $1 billion
Well, the richest
to buy
person in
another
history
golf
and
course.
the ex-richest person in history live next to each other. It's plausible.
I still couldn't hear you.
But anyway, back to this. Any more discussion? So we're ready for this open house, this public hearing?
Well, it's just a open house, it's
Open
not a
house.
public hearing.
Well,
Yeah.
whichever we want to.
I think I said that.
I believe we're ready, yes.
Yeah, I mean, I still got a few more tweaks, and then what we'll do is we'll actually create, the idea is that we'll then try to create some, I gotta talk to OTEC, but we'll try to create using these things, some visuals and stuff. I think you guys are planning to have a table there, so if people have specific questions about St. Thomas's project, they're there to answer. I've asked them not to have a whole slew of people, but kind of keep it down to a minimum number, because this is not St. Thomas's open house. It's an open house for both the rezone and the school height issue. So it's both of those things are actually going to be part of the open house. And that's important about the rezone being part of this too.
And since it's an open house, the fact that you're going to tweak this a little bit more is okay.
Yeah.
We don't need a specific draft out to the public
I will,
before.
yeah, I'll bring a draft. I'll actually, at the next planning commission meeting, you'll see the draft that'll be there. I'll actually have it available for you guys to take a look at. Yeah, so
Before we adjourn, when was the next meeting? Because I've heard you wanted to move.
18th, it's already been done.
April 18th, right?
Yeah.
Just making sure I got the correct date. Everybody's noticed?
Yeah.
Okay.
And then the open house is following week. Because I'll be gone from Friday through Tuesday. I'm at a
So
conference.
the April 3rd?
No, the
Or the
25th. 25th.
25th, a
Yeah.
week, exactly a week, okay.
Yep, 1 week.
So what was going to be the original?
No, well, the planning commission meeting is Tuesday, and we're going to be Wednesday.
So
with the open
Wednesday, the
house.
25th is the open house.
And again, if you're not able to make the open house, it's fine, but it's just walk-in. So again, if you come and you need to leave during the course of it, it's fine. It's just walk-in between 4:30 and, what did I say, 7 or 7:30? 4:30 and 7:30, so it's just a walk-in for people whenever during that time. So we figured that would be the easiest way, that way it's convenient for folks. We usually, to be honest with you, we usually don't get a lot of people turning out for these things, so I'll be curious to see if we have, what we have turning out. I think one of the most successful, or one of the biggest open house turnouts we've had was probably maybe about 20 people.
Was that the tree code one?
No, actually, I think it was 84th project.
Did we notice both the other schools that were doing this?
I have not contacted the schools. I don't know if they're aware or not, other than this postcard notice, but we can send something to them. I don't have a direct contact anymore. I used to Bellevue Christian, but the principal there's gone, so I don't know the new principal. Do any of you guys have, otherwise I can check with the chief. I can see who the contacts are, maybe.
We reached out to the facilities director for the entire school district and left a voicemail and an email with him.
Okay.
Have not heard back from him, so we'll probably keep him in the loop.
All right.
Just checking about-
I'll check with the chief though too, because I know chief has some direct contacts. My guess is the schools probably aren't going to have a whole lot to say, but if they do, that'd be great. I mean, it'd be amazing if they do.
I'd be curious to see what they have to say about these setbacks, but the noise, I think, will be one of the biggest determinants in that, so.
Yeah, just what I know about noise, I mean, other than it carrying a little bit further, I'm not sure the difference between a rooftop and down below. The main difference that's going to happen with St. Thomas is right now, down below, you've got buildings and stuff that help contain it.
Yeah.
And of course, those buildings will disappear on the upper level when it goes up higher, because they're not going to be in the way there anymore.
But even that would be good information, I think, to have.
Yeah,
for the
absolutely.
Planning Commission and the council, so so.
Well, and then one of our council members has indicated that she can hear St. Thomas, even at the ground level. She can hear them, the kids playing, and she's a little bit of a distance, so, yeah.
She's on 14th.
Yes.
I move,
I can
move
hear
to
Brother
adjourn?
Christian.
All right, Jeannie.
Move to adjourn.
Second.
All four?
Aye.
Opposed?
All
Adjourned.
right, thank you, everyone.
Yeah, I can hear Bellevue Christian. I think we're 5 minutes.